Remember, the background to this is the point I made earlier, namely that any order of a court of law is rescindable. Any order. Doesn't matter.
260.
Yes. Doesn't matter that it might be
260 of the main bundle. I see it's part of a letter.
Yes. I'm just giving the back. Yeah, the background to this is the submission I had made that there's no limitation to what orders can be rescinded, at least that I know of. Not in the common law, not in Section 42 of
Rule 42.
I mean Rule 42. Thank you, and not in terms of Section 172. Certainly not in terms of Section 172, because that's and even 45A. All those four standards don't say they are orders. But here, just because it is the so-called Stalingrad police, they say that this rescission application was something that was like an afterthought and something that was meant as a delaying tactic. I'll look at paragraph 8. This is a letter that Mr. Sianeho, my attorney, wrote as far back as 23rd March 2022, and it related to this issue of the so-called letter of request, even before the alleged judicial capture allegations. At paragraph 8, it says, to entertain or even act in accordance with such a, quote, letter of request would be patently unconventional, if not downright irregular, and would certainly constitute a new rescindable error, in addition to the grounds raised in the relevant applications. Rules cannot be made in an impromptu fashion for specific litigants as we move along. So even then, before Mr. Abram G came into the picture, we foreshadowed that should the so-called urgent entertainment of the rescission, which has now happened, as Mr. Abramji predicted, that if that happens, then that would be a rescindable error in its own right. That's what we said then. And the reason why we are confident now to say that Mr. Abramji is either a sangoma or there's something more serious to it is because, as it happens, your lordships will know, Mr. Justice Erasmus referred to it earlier, about the rescission of the earlier judgment. That rescission, as your lordships know, was submitted, I think, on the 23rd of July 2021. I might be wrong about the date, but it was certainly July 2021. And the ruling came about 8 months later, in February, March, actually, in early March. So compared to that, this one took 6 weeks or something like that. So it's clear that it was a response to that letter of agency. I mean, agency that's pleaded in a letter, I've never heard, but be that as it may.
How can you say it's in response to the letter? It's clear that it's in response. The letter is written by the state attorney on behalf of
the speaker.
The speaker,
yes.
And it's sent simultaneously with the
notice to
oppose the rescission application.
Correct.
And I've looked at the email addresses. So it's the chief registrar, the admin in the general office, the director of the Concord. So those are admin people, and Visagi at Concord.
Yeah.
And then they request that certain information be brought to the attention of the acting chief justice.
Chief Justice, yes.
Now, the acting chief justice was not part of the panel that decided the matter. And therein is an indication of the timelines that Parliament has, the 194 committee, and the request is the following. We are further instructed by the Speaker to respectfully request that if the Acting Chief Justice decides to issue directions, that's the Rule 18 directions,
18.4,
for the filing of papers by the parties, then, if at all possible, in the light of the public interest in the finalization, one way or the other, of the process for the impeachment of the Public Protector, such that directions be aimed at enabling the court to reach a decision, a decision on the decision application before 4 May 2022. Now, this happens every day, that parties' attorneys would write to the leader of a court, the judge president, for example, requesting early allocations or indicate why a matter should preferably be placed before a full court, etc. You will know from your experience, I will know from my experience, and also I headed a court at some stage. How can you say that they've expedited simply because of this letter?
Okay, thank you. Let me assist you, Justice Erasmus. Firstly, it does not happen every day, not in the Constitutional Court, because there is no equivalent mechanism. I'm sure I was lucky the first time. I'm sure no one has got volume 1 of Erasmus. But there is no equivalent mechanism like the practice directions that were given by the president of the SCA on the 14th, I think, of July 2014, which say that if there's an appeal and you want it to be expedited, this is what you must do, blah, blah, blah. It's set out. That there was a reason why it was set out in the because they were saying everyone, all sorts of people are writing to the registrar and so on, which is what you say happens every day. It was to stop exactly that. And that's why the direction was given. In the Constitutional Court, there is no similar mechanism. That's number one. Number two, what happens every day, actually, in all courts around the whole country, is that if you have a reason for urgency, you must put it in an affidavit. Why is that so? Because that does away with the abuse, which is what this is, of writing a letter that nobody, there's no comeback. You just write a letter. The reason why urgency is argued in affidavit is because the other person who might not feel that it's urgent will then put their own affidavit on the oath and say why it is not urgent. That's what happens every day, right? Now, so that's number two. Number three, I've just given you a comparison, Justice Erasmus, about a rescission application between the same parties, which took 7 or 8 months to decide. And you expect the public protector to believe that this one that took 6 weeks, after her experience of an 8-month wait, the one that takes 6 weeks was not because of the so-called request? No, I'm sorry.
It goes further, Mr. Mpofu. When it was sent, and I don't know whether it was transmitted electronically to the other parties as well, because the whole list of the participants in the previous
it certainly
case,
came to us, yes.
It was sent, and then your attorney then immediately, 5 days later, on the 23rd, he submitted his response to the registrar, the same...
The one I was reading to you now.
Yeah, and he just copied in a further person, Matiba at Concord. And the decision was only given on the 6th.
Yeah.
No, I know what you're going to say about that. But I'm saying that was the 6th of May.
Yes.
So this was in March, and in the decision given, the panel, not the Chief Justice, the panel says there was no need for directions to be issued. And therefore, we're dismissing it on the
Yes.
papers.
Right. Okay.
Just to complete the timeline.
No, thank you. Thank you. I'm indebted to your lordship. Enter Mr. Abram G. This is exactly the biggest scandal ever to hit our courts, because Mr. Abram G says to Mr. Breitenbach on the 24th, don't worry, Mr. Breitenbach, let the Mpofus and the Masukus of this world be busy preparing. You can go fishing, because the Constitutional Court is going to give the judgment you want on next Friday, right? Which is the 29th. Now, that, if anyone wants us to believe that, let's just say for a minute that the judgment came on the 29th. I'll come to the issue of the 6th. That was not in compliance with this letter that says this must be done before the 4th, because all sorts of things, including lies, which we pointed out, have been said not under oath as in the usual way. Then, I mean, I don't think anybody can argue that. That's the first thing. The second thing is that the mere fact that the judgment is delayed by a week, I mean, we're not children. The mere fact that it's delayed by a week cannot, by any stretch of the imagination, be read to mean that what Abram G was saying was not going to happen on the 29th if it had not been outed. So let's just stop there. So really, to believe that a judgment which, and you will work with me here, Justice Erasmus, which would have been given, all things being equal, on the Friday before the 4th happened, was just fortuitous, unrelated to the request for that judgment to be given before the 4th of May. It is beyond my comprehension.
But that will require that the Constitutional Court, for that theory, the Constitutional Court must have withheld something.
No.
Remember, Abraham G says 29.
Yes.
You don't get the judgment on the 29. What had happened? One, either the judgment was not ready and was not going to be given on that day. The alternative is somebody said, oh, we must cover up.
No, those are not. Yes, no, I agree. Those are the alternatives, but those are not the only alternatives. The other alternative is that, as we know now, actually it's not even an alternative, it's a reality. On the 28th of April, yes, the date before the Abram G prediction, the Chief Justice gave an interview on SABC, right? He said, he was asked 3 times, has the decision been made? He gave 3 different answers. The first one was, it's in the...
You filed the transcript of the...
Yeah. It's volume 2, page 152 of the new, of the supplementary index, what we call the supplementary index. 152, my lord.
Yes.
First time the question is asked. Before I get into that question, I prefer asking this way: is there a decision around the issue of the public protector that is pending, imminent, not eminent, imminent? Then the Chief Justice says, well, the matter is pending before the Constitutional Court. The Constitutional Court will announce its decision when it is ready. Let's just pause there. He's not saying a decision is not made. He's saying it will announce it when it is ready. That's a completely different thing to what is being asked, but let's just pause there for now. Then the reporter tries again. Has a decision been taken? Then, Chief Justice, the Constitutional Court will announce when a decision has been taken.
The first question was whether it's imminent.
Yes.
Right?
Yeah,
And
but
then he
the
says-
same answer was
then
given.
he says he will announce when it's ready.
When it's ready, yeah. Which, as I've said, in anybody's language, it doesn't mean that it's not. It will announce when it's ready. It doesn't mean.
Because it is also stated in an affidavit,
Yes.
in these further affidavits.
Yes.
And it's set out, and then it says, unfortunately, the Chief Justice 3 times gave different answers.
Yes.
And
I'm going through that now.
by implication saying he lied.
No. The,
How
the-
else must I read it?
no, well, I don't know, Justice Erasmus. I'll tell you how the public
That's what the
protector.
deponent says. in
Yes.
that
Well, I'll tell you how the public protector read it. Okay. The public protector explains exactly how she read it. Firstly, let me just finish the sequence. So again, the interviewer tries for the third time. So the decision has not been taken, and then Chief Justice, the Constitutional Court has not yet announced a decision, and therefore there is no decision that has been taken, whatever.
So the first question was whether it's imminent. And then he doesn't say whether it's been taken or not. He says
He says it
they
will be
announce
announced.
it when it is ready.
Yes, he doesn't
Then
answer the question.
He follows up, has it been taken? It's a different question to the first one.
Well, it's the answers that I'm
It's a
worried
different
about.
question to the first one.
No. It says, is there a decision? It's the same question. Is there a decision or is there not? All right? Before I get to the question, I prefer asking this way. Is there a decision? Okay? Around the issue that is pending and imminent.
No. Why do you place the emphasis on is there a decision?
All right.
The
I'm not
question
going to.
reads, the question reads, where he asks the question. He first gives an explanation, background to the question, then he says, before I get into that question, I prefer asking this way, is there a decision around the issue of Public Protector Mkhwebane that is pending, imminent?
Yes.
And then the Chief Justice answers, says, well, the matter is pending before the Constitutional Court. The Constitutional Court will announce its decision when it is ready.
Yes.
Then he says, he now asked, has it been taken? Then the Chief Justice answers, he says, the Constitutional Court will announce when a decision has been taken. Then he follows up and he says, so the decision has not been taken. And then he ends the sentence by saying, therefore, there is no decision that has been taken.
Yes. Okay. No, well, I don't
So
know
where's
where
the-
there's no misunderstanding.
Where's the 3 different stories?
Yes. The
in-
first one. Okay. I'll
That
try.
the deponent says. in
Yeah.
the
Let me
affidavit.
try again.
I don't know exactly
Actually,
we said it.
actually now on this analysis, there's a fourth one coming. The first one is there a decision that is imminent? That is imminent. Sorry, as you correctly point out. Is there a decision that is imminent? The answer doesn't answer the question. It says, well, the matter is pending before the Constitutional Court. The Constitutional Court will announce its decision when it is ready. So the question, is there a decision that is imminent or not, has not been answered. Let's at least agree on that. Then he says, and I'll take your slant on it. Has a decision been taken? Let's assume that is a different question for now. Then he says, the Constitutional Court will announce when a decision has been taken. Again, the question is straightforward. Has a decision been taken? Yes, no. And then that's why he asks for the third time. So the decision has not been taken. And then he says the Constitutional Court has not yet announced a decision. Therefore, there's no decision that has been taken. So at that point, we now have the version that no decision has been taken. Okay? Now go to the what I call the fourth version. But what do you make of that which I've just said in terms of someone texting and saying that I have it on good authority that the court will decline the rescission application? You may not have been privy to this, but it's out there in public and people are speaking about it. And let me pause there. This is the harmful or the painful part about this. This court, when it adjourned or postponed the matter on the 26th, correctly, with respect, correctly said, or at least agreed with the parties that two things should happen. Clarity must be given on what happened. This is not clarity. Secondly, the dignity of the judiciary, I'm paraphrasing, in that process must be protected. And that's what this journalist is saying. Says this thing is out there and people are talking about it. This is the response. So let's assume he's now prodding for the fourth time. Yeah. So here's the response. Well, of course, one can't control what one person communicates to somebody else. This came to my attention and I've decided that it should be investigated. It is being investigated, and once there is finality, we'll let the public know, but certainly it's something that's very concerning. And well, I said to you earlier, on the Constitutional Court hasn't taken a decision. I must say to you, I said to you earlier, most of the time I was in meetings. If it has taken a decision, so for the first time now, the possibility of a decision being taken is introduced.
No, read further.
Yeah, that's exactly what I'm going to do. If it has taken, I was just pausing to emphasize that part. If it has taken a decision in my absence, then Chief Justice is laughing. Then it says that might have, but certainly, as far as I'm aware, it hasn't taken a decision. If it has, again, introducing the possibility that it might be taken. Any decision, it would have been during the time that I have been in meetings. So I just thought I must explain that, but certainly it's completely unacceptable, whatever, which we all know it's unacceptable. But the point I'm simply making is made in the Public Protector's affidavit. This is PCA 2. You'll find that, my lord, at I'm looking for the.
It will be on that.
Where it refers to that.
Volume 1 of 4.
Volume 2 of 4. 2
of 4.
Where we refer to this letter. This was 20. I'm sorry, my lord. I'll find it.
I think it was in 1 of 4.
No, not a letter. It's in the factual analysis of what has happened since the since the Rule 65E application, I'll find it just now.
Yeah. It will be.
Yes.
It will be here where I found the.
In the supplementary index.
Yeah.
Okay, I need this. It's very important.
That's the one where.
It's the recent one that came on Sunday, my lord. Yes.
Yeah, that's it's in volume 2 of
152.
4.
I'm told it's 152.
No, 152 is the transcript.
152 is the transcript. Yes, I'm just looking to where it is referred to in the affidavit. Thank you. Yeah. Okay. Sorry. Yes. No. It's an earlier page 14. Page 14. 1 of 4. Yes.
Yeah.
Yes. This is what is said, my lord, and if this doesn't make sense, then I don't know. So, a crucial development, sorry, I'm starting at page 13, 1-3. A crucial development which is somehow left out of the RPN, that is the respondents left this out for some reason, is that on 28 April, and shortly prior to the above-mentioned letter from the Constitutional Court, the Chief Justice gave an interview on SABC television, she says. In the interview, and regarding the issue of the decision referred to in Mr. Abramji's SMS, the Honorable Chief Justice, with respect, did not give a clear and unambiguous answer, and that I've just explained that. Importantly, the Chief Justice acknowledged that, quote, it is completely unacceptable for anybody to say that anybody that the court has made any decision that the court has not announced. Let's just pause there. Look at that statement. It is completely unacceptable for anybody to say to anybody a court has made any decision that the court has not announced. Those are words, actually that's the fifth of these versions. So you could have said, to say anybody, the court has made a decision that the court has not made. But it says that the court has not announced. Okay? I say these utterances tend to indicate, inter alia, which I've explained earlier, that some decision may well have indeed already been made, but not yet announced. That is self-evident. The second, then we say, when the interviewer repeated the question with a view to seek clarity on this issue, the Chief Justice then seemingly categorically stated that no decision has been made. So that's the second thing. However, later during the same interview, the Chief Justice sought to explain the issue by giving a third version and stating that the Constitutional Court may have made a decision referred to by Mr. Abramji in his absence, that is the Chief Justice, during the time that he had been busy in meetings. This is now the part that really comes to, owing to the resultant confusion on my part about what the actual position was. In other words, it's the public protector here speaking, saying, I'm faced with this, and I'm faced with these 3 or 4 versions that come from this. And then owing to the resultant confusion on my part about what the actual position was, I instructed my attorneys to seek clarity. No one can fault her for doing that. If deemed necessary, a video clip of the interview will be played for the court, For ease of reference, I've taken the liberty to request my attorneys to prepare a transcript of the interview. Here's the thing. It says then, I later addressed on 3 May a letter to the Chief Justice. In other words, simply to seek clarity, because this is as clear as mud. So to seek clarity, she wrote a letter dated PCN PC7. To save time, I will not go to that. But that letter simply said the same thing that the journalist was grappling with. Has a decision been made, or has it simply not been announced, and so on and so on. I've gone through all that.
Isn't it because it was a press conference or an
Yes.
interview and not in an affidavit?
Fair enough.
And not under cross-examination?
Yes. No, fair enough. No, I agree with that 1,000%, Justice Delamo. That's exactly why the letter was written. Yes, exactly. Yeah, because we could have just said, oh, well, here's the interview and go mad. No. The public protector did the responsible thing because of what you are saying, Justice Delamo. To say, well, maybe, you get ambushed by journalists and so on, and you're answering on the spur of the moment. Let's write a letter and ask the questions nicely, set them out nicely. And that you'll find at PN7.
Page 77 at that time.
Page 77. Thank you, I'm indebted to your Lordship. And that letter, it's a nice letter. It's not a fighting letter. It says the response, because remember, after this, what makes it worse now is that a few days after this, you get, not a few days, the following day, we then get the letter from the Chief Justice, which says there is an investigation. The Chief Justice stated that the Constitutional Court may have made a decision referred to by Mr. Abraham G. in his absence, quote, during the time that he had been in meetings. And then paragraph 8 says, these statements do not make sense in light of the applicable rules. They raise, among others, the following pertinent questions which need to be clarified. Really, for someone to ask for clarity and be faulted for that. It says 8.1. As it so appears, has a decision already been taken that the matter is only awaiting an outcome? That is, without, 1, issuing the Chief Justice's directions in terms of Rule 18 or requiring the Speaker to submit answering affidavit. If so, when and on what specific date was that decision taken? And then 8.3, has another decision been made to dismiss the rescission application, albeit in the absence and without the knowledge of the Chief Justice? 8.4, by whom was that decision taken? 8.5, if so, who, apart from the Chief Justice, could have taken a decision to dismiss the application without the knowledge of the Chief Justice? And how is it that even a possibility in view of the clear, how is that even a possibility in view of the clear wording of the requirements of Rule 18? 8.6, is the factual position that no decision has been made underlined, or merely that the decision has not been announced and underlined, which is unclear from the thing. And that's the most important one. In terms of the Constitutional Court, is it permissible for an outcome as indicated by the Chief Justice without the Chief Justice having given any directions, or even worse, without his knowledge? The important question there is 8.6. Is the factual position that no decision has been made, or merely that the decision has not been announced? Could have been, again, for the fourth or fifth or sixth time, a simple answer of saying, no, you've got it wrong. There's no confusion. The decision has been made, but not announced, or the decision has not been made and not announced. In fact, the issue of announcement would be irrelevant, quite frankly, if the decision had not been made. Yeah. That's just common sense. So to invoke the issue of announcement alone raises the specter that there's a decision. But be that as it may, the answer that we got from this was simply to say, we won't engage when seeking that clarity.
Did the answer and the order come at the same time?
No, the answer came on the
Sixth.
I don't know which came first, but they came on the same day, at least, not at the same time.
Person, by Stephen Cindy.
Yes.
Both were signed by that person.
Yes, but
They both date stamped with the Constitutional
Same date,
Court
yes.
Registrar's date stamp
I've said that. Yeah.
on the same day.
Yeah.
And I take it was sent via electronic means. So
I don't know, but let's assume that is so. To move on, let's
that
assume
it was
it's simultaneous. Let's assume it came boom.
It was sent simultaneously.
Yes.
I don't know.
Neither do I, but let's
when
assume.
one looks at the second part of the reply letter, it says we stand by our letter of the 29th.
Yeah,
I'm
so-
paraphrasing.
Yeah.
And then if you go to the letter of the 29th, insofar as it relates to the allegations, they say it's currently
Yeah.
being investigated, and then says
The decision will be announced. So
that
it
will be communicated to the parties when the court has finalized its processes and made its decision.
Yes, that's true. But that's why I'm saying let's assume in their favor, whoever was sending this thing, that it was sent simultaneously from literally or in whatever sequence. That's not what I'm busy with. I'm saying that the point about the decision which was given is one thing, all right? The issue about the investigation of how the decision was leaked to Mr. Abraham G is quite another, all right? So it doesn't matter what sequence the letters, I'm sorry, Justice Tolam.
You say these are two different.
Yes,
What
or different processes, yeah.
What should concern us then? Is it the outcome or the
No, thank you. Thank you. That's a very good question. With respect, Justice Tolam, what should concern you is a situation where there is a possibility, and I will not put it higher than that. There is a possibility out there that somebody in the Constitutional Court leaked a judgment to influence this court, with respect. Not out of fun or as a joyride, but to influence the three justices sitting here. If that was not the case, that SMS would not have been sent to Advocate Breitenbach. It would have been sent to me, or Mr. Masuku, or whoever. It is a deliberate act of criminality and corruption to take that information. In terms of the definition of corruption in our law, Section 3 of the Corruption Act and Section 8, which deals with judicial officers, corruption in relation to judicial officers, say that if there is any activity which suggests, and this is how it becomes corruption, Justice Dolamo. As far as Mr. Abraham G is concerned, obviously it's corruption and scandalizing the court. There's no doubt about that. The common law crime of contempt of court. But as far as his source is concerned, whoever that might be, and we don't know, it could be a clerk, it could be someone in the registrar's office, it could be a judge, it could be anybody, we don't know. That's what the public protector says. As far as that person, the deep throat inside the court is concerned, it's an act of corruption. There is no doubt about that. There can be no doubt about it. Right? Now, but it's not the point to answer your question directly. It's not an act of corruption in the air. It's an act of corruption to influence this court. Because the only reason why Mr. Abraham G sends this to Mr. Breitenbach is to advantage to my learned friend. My learned friend, Mr. Breitenbach, is just a conduit. He has no part in this. It could have been anybody. It could have been Counsel van der Merwe or anybody else. So he's not the target. The target is the speaker and the committee that Mr. Breitenbach acts for. It's to advantage them. By the same token, it's not to disadvantage me. It's to disadvantage the public protector. All right? So those are the parties before you, before this court. And for those two reasons, because it was to influence you and to influence the outcome of this process, but also to advantage one party over the other, it should concern you. Not that you should, obviously all of us were in the same boat. The investigation and its outcomes and the police and what have you, this court cannot do anything about that. But to try and argue that that's a side issue, that is not, I mean, the committee even says, no, that has nothing to do with us. How can it have nothing to do with them when it was given to their advocate for their benefit? But anyway, that's as far as that issue is concerned. Coming to the issue of the I will start with the issue of the interpretation, right, of Section 194(3)(a). I do that deliberately because that issue covers both, or not both, all the respondents except for the DA, unlike the conflict issue which only covers the president. Right. So let me explain again, Justice Dolamo. It's linked to what you're asking me. Why must this concern you? All these shenanigans. It is because there is clearly, and I say this with no fear of contradiction, because that's what the public protector says in her affidavit. That what seems to be happening here, if you cut out all the nice English words, is that one woman, is being, in a coordinated fashion, victimized by the most powerful forces in this country ever to be imagined. The head of state, no higher force there is than that. Mogoeng CJ explained it in the Nkandla judgment. He is a constitutional being. All our hopes are on him. The Speaker of Parliament, the head of the legislature, we've said what we've said about her. The Chief Justice, the head of the judiciary, I've said what I'm saying about him, bearing in mind that he's also mentioned in the main before Mr. Abramji's thing anyway, in terms of the conflict. We'll come to that. And really, now, the NGOs are not even going there in the media, but who are represented collectively by Mr. Abramji. So you've got, which is called the fourth estate in colloquial language. So I've got all the four estates of the state, imaginable. Top, except for Mr. Abramji, the heads of those things. Against a lonesome woman who's just trying to do her job. So her perception is that the entire network, for lack of not even mention the chair of the committee, that's another story. But that whole network is loaded against her. How can a court of justice, not a court of law, a court of justice, not take that into account? To say, wait a minute, what is actually happening here? We've got all these papers and what, but let's take a breath and a break. What is actually going on here? That will be your privilege. But the point I'm making is, going back to section 194.3a, is that section, it is very clear that it is triggered at the point at which the start of the proceedings happens. In fact, it's even worse than that, because the Constitution uses the word after. So it's not even upon. Remember 177.3 that I read about the judges. Just says upon being reaching a particular stage. Here it says after the start of the proceedings. And we must accept or assume that the founding mothers and fathers of the Constitution knew what they were doing when they were affording the public protector that kind of protection. To say she can only be suspended after the start of the proceedings for her removal. It's a deliberate protection, which is higher than that of the judge, and which is, well, the president has no suspension provision. But the words do not just fall from the sky. What do they mean by after the start of the proceedings? Here you're going to see the most blatant dishonesty in dealing with this question. And I say those words advisedly. The president, let's start with him, said to one of these to a Mr. Hoffman, I'm sorry, I think it's there. 555 or 525. I'm sorry, my lord. 525. I'll paraphrase for now. The president said to Mr. Hoffman in January last year, three things. Mr. Hoffman was agitating, like everyone else, for the suspension of the public protector in January last year already. The president said three things which were very interesting. He said, I cannot suspend because I'm conflicted. Okay? I'm just paraphrasing. I'll come to it. Secondly, I cannot suspend because the proceedings have not started. and therefore section 194.3a is not triggered. Those are his words. All right. Let me sorry, my lord. Okay. Murphy's Law. Just the one volume you are looking for. It's the one that you will not find. 5.2. That's 400. Anyway, he says that, which means two things: that the president was aware, fully aware of these two issues that we raise here, that conflict of interest and the triggering of 194 are an impediment to suspending. Yes. Okay. Now, guys, please. The letter starts at 524.
Page 524.
524, yes, and goes on to 525. Volume 6, I'm sorry, my lord.
In the main.
The main pleading span, yeah, that's correct. Paragraph 3, this is the president writing to Mr. Hoffman, Ms. Lusanda Mkhwebane, acting director and secretary for the cabinet and so on behalf of the presidency. You see in the letterhead at 524. In your emails, you suggest that the president has a discretionary power under section 194.3 and so on. I'll jump to 3. You are correct in raising the possibility of a conflict of interest in your latest email. Kindly be informed that the president gave an undertaking to the Western Cape High Court Western Cape High Court pending matter case number 2107-2020. That's where the connection between that matter and this one really is. Where the public protector is challenging, amongst other things, the validity of the rules adopted by the National Assembly for the removal of the heads of commissioners of Chapter 9 institution. The president's undertaking is that he will not exercise powers under section 194.3 while the Constitutional Court has not delivered its judgment on pending litigation between the president and the public protector, and will delegate the exercise of the power to another member of cabinet.
Now, besides this case, where the president is also a respondent, is there any other pending, and of course the rescission application, is there any other pending litigation?
I'll come to that just now. Can I finish?
Yeah.
The president has considered your request but has not delegated its consideration to another member because no proceedings by a committee of the National Assembly has set up to consider the removal of the public protector have commenced. In other words, section 194.3a of the Constitution is not engaged at this stage, and I will show that that we are still there now. And then here's the interesting one, which shows the conspiracy and the what I call the network. It says, furthermore, that's paragraph 6. The president will not be involved in the processes of the National Assembly considering the removal of the public protector. He will have to wait for a request from the speaker, as contemplated in the rules. Well, there's no such thing in the rules. Before he can consider exercising the powers under 194.3a of the Constitution. In the Speaker's request, the President will be provided with a copy of the independent panel and so on and so on. Well, let's start there before I come to your question, Justice. What he's saying at paragraph 6 is exactly what happened on the 10th March, where he was being obviously prompted by the Speaker to suspend. That's why he said he won't just wake up and do it. The Speaker will have to request it. But now the request is couched dishonestly as a so-called, what do you call it? Courtesy letter. Okay. But this is what the President said he would wait for. Let's move with it slowly. Section 194.3a, let's flag that, we'll come to that. Let's come to Justice Erasmus's question. And that is there any pending litigation? The first answer is yes. The second answer is it doesn't matter. Let me explain. There is pending litigation in the sense that the real question about the President's involvement in the Busasa scandal, CR17 scandal, is yet to be answered when the pending litigation around the unsealing of those documents is finalized. So it's pending in that sense, common cause. There's no debate about that. The question is what do we contend to be the implications of that? If you read any of the judgments, High Court judgment of Mlambo, JP and others, and the Concord judgment, well, even anybody in the street knows this. The gist of why the courts said that the public protector does not have jurisdiction over that matter was because they say it is a personal donation to do with the ANC and not a public thing. That you have to believe. So that was the gist of the thing. In other words, there was no, from the donors, there was no expectation that he'll become the president of the country. It was just, they were just being generous to a member of a party. And who? He became the president of the country. Fine. So that's the gist. Now the reason why that theory can even be sustained, I mean, ridiculous in the affidavit, it's even expanded by various people in ways that I don't want to go into. But the only reason why our courts believe that theory, and you can't blame the court, is because the documents were sealed. Right? What was the court going to do? The court cannot say we can agree that Mr. Masuku donated the money for nefarious purposes because the documents are sealed. So the pending case now about the unsealing of the documents is directly related to the conflict that the president suffers. In other words, in simple terms, if that court says that let's expose the Mr. Masukus of this world, and it comes out of that unsealing that Mr. Masuku indeed, for not very holy reasons, donated there. And Mr. Masuku was expecting to get a tender, for example.
I have to object on behalf of Mr. Masuku.
Okay. Objection sustained. From him, yes. Well, Mr. Masuku unfortunately happens to be my junior in another matter, so I'm sure he had to constrain himself. Thank you, Justice Villa. Yes. Okay. Yes, let's just call him Mr. X. Mr. X. If it is found that Mr. X donated for the purposes of securing tenders, for argument's sake, then immediately the jurisdiction of the public protector is engaged. So the entire edifice of the so-called finality in the Busasa judgments will fall away, because that judgment will unveil the donors of the 1 billion rand. And so, so that's the first answer, that actually, if you look beyond the obvious, that matter is not by any stretch of the imagination. One day, those documents will be unsealed. But let's put that aside. Let's assume I'm wrong about that. Okay? Let's assume that Mr. X and the donations and this is the end of the matter forever. Amen. Let's assume that. Make that incorrect assumption. Then it comes to Justice Erasmus's question. And this I have to say very slowly. If Mr. Mpofu, you are saying, let's assume that the Busasa thing will never be reopened, then, or that there's no possibility that the court in the next 2 weeks might actually unseal the documents, which might happen, by the way. The SCA might say it might be unsealed, or the Concord, or whatever. But let's assume I'm wrong. Then what is left? It is the 3 pending investigations by the public protector. The one is the allegations of judicial capture involving the president on one of the complaints. The other one is the allegation of the Zimbabwe trip, where by some coincidence the speaker, the current speaker, when she was still Minister of Defense, took her friends from the ANC on a trip to Zimbabwe on a government aeroplane. Again, we must assume this is a coincidence. It's the same person, by the way, to go back to Justice Vele's question. It's not the office of the speaker, it's Ms. Mapisa Makula. That person, who is part of the network I've just explained, is being investigated for having flouted the law, and in fact, she has even been sanctioned by the president for doing that. So that's ongoing investigation number 2, right? The third ongoing investigation involves the president in the Scopa matter, where he said in a meeting that he was aware of people abusing public funds to run ANC errands. Those are 3 ongoing investigations. It is common cause.
Now, assuming we are with you
on that
the president is
conflicted.
And assuming we are with you that the
Process has not started.
has not started, what will be the effect thereof
Yes.
on the work of the Section 194 committee?
Very good. Thank you. I'm sorry, Judge Telama. I'm not patronizing you. I'm just, it's because it just comes to what was my next point. I apologize. If I may, please, Justice Telama, beg you, if can I just pack that just to finish the question of Justice Erasmus? Sorry, I'll write it down so that I don't forget your question. Right. Here's the thing. The source of the conflict, the admitted conflict by the President of South Africa, which he repeats to Mr. Hoffman and others, is not so much the fact that there is pending litigation. It is the implications thereof. He says in one of his affidavits, I can understand why someone might think that if there is this pending litigation and the adversary, then I might want to get rid, quote unquote. I hope I'm not misquoting the president. I might want to get rid of that person who's my rival. I must emphasize that sorry. Yeah, you'll find that at page 204 of volume 3. He says under oath, paragraph 26, I respectfully say and accept that a potential conflict of interest arises from the pending litigation between the public protector and I, not the findings that the public protector made against me. In recognition of this, I accept that I am duty bound, right, to act so as to exclude the possibility or the perception of bias affecting the outcome of any decision that I may make in relation to my powers under section 194(3) of the Constitution. Here's the sting. This is necessary in order to protect the integrity and legitimacy of the Constitution and the process followed in relation thereto. I can assure you that those words come from one of the cases in the Big Five, which is the president versus the public protector. That's the Gauteng case, the so-called state of capture. By the way, if I may just pause there and just give you these cases quickly, the so-called Big Five cases. Case 1, I said, was the impeachment case. That is 2018-2-571. That's economic freedom fighters versus the Speaker. Case number 2 is the Nkandla case. That's the EFF versus the Speaker. You'll find that at 2016-3-580. And in our case list, I'll refer to it. Case number 3 is the UDM case. That's I referred to it earlier. And that is case number 90 in file number 5. Yeah, Nkandla is case number 3. That's 2016-3-580 CC. And UDM, which is case number 3, you'll find this case number 90, which you'll find at 1992 of the bundle of cases. That one is 2017-5 SA 300. And then case number 4 is this one that we're dealing with now. President versus Public Protector, 2018-2-160. That's case number 18 on the list. That was case number 4. Yes, and case number 5 is the judgment of the Constitutional Court in this matter. That's the Mdntv J judgment. That you will find, it appears twice at page 97 of volume 2, but also at page 1938 of the other volumes. So the words that the president, to come back to Justice Erasmus, was saying here come from there. And the importance is this, Justice Erasmus. There are 3 forms of conflict that affect you if you are the president of the country. The first one is the one that affects everyone else, me and everyone, an actual conflict. If I'm conflicted, I'm sitting in a board meeting, I must recuse. The second one is the potential or reasonably apprehended conflict by the victim of that conflict, for lack of a better word. But the third one, which is important, is the one that arises from Section 96(2)(b) of the Constitution. That one is special because it's not like the conflicts that arise like everyone else. It only arises by you accepting to become a member of the cabinet, like the president. And that's the importance of this, Justice Erasmus. It says, members of the cabinet, and that includes the president, may not act in any way that is inconsistent with their office. That's the first thing. They may not breach the oath of office, for example. Or, which is a separate thing, expose themselves to any situation involving the risk of a conflict between their official responsibilities and private interests. The risk. Justice Mkhwebane explained this in the Nkandla judgment. He said the risk doesn't even have to eventuate. The risk is enough. And that's what the president himself was alluding to when he says, I will recuse myself so as to exclude that risk or that possibility. So this is the reality of the situation, Justice Erasmus. If we accept that there are three, for now let's say there's no pending litigation, but there are three ongoing investigations, which is common cause, then I'll ask this rhetorical question. Which one is more likely to raise a conflict? Which one, really? Between ongoing litigation, where you are the respondent, what's the worst thing that can happen? Maybe you'll get a cost order against yourself. If that raises a potential conflict, how on earth can three investigations relating to three serious offenses, impeachable offenses, each one would have been enough, but three, all of them may result in the impeachment of the president. Which one is the calamity that would raise a conflict? Is it because he's a respondent in some litigation on Busasa, or the fact that he is in jeopardy of losing his job? Please, let's the situation that the president is facing as a result of, in fact, Justice Erasmus, let's do this exercise. For the word litigation, I'll use the word investigation, just to emphasize this point. Then this is what the president is saying. I respectfully say and accept that a potential conflict of interest arises from the pending litigation, he says, and I say investigation, between the public protector and I, not the findings, whatever. In recognition of these three things, I accept that I'm duty-bound to act so as to exclude the possibility or the perception, or you might add the risk of bias affecting the outcome of any decision that I may take in relation to my powers under 194(3) of the Constitution. This is necessary in order to protect the integrity and legitimacy of the Constitution and process followed in relation thereto. It's what we lawyers call a fortiori. If he perceives a risk by his status as a respondent in litigation, then a fortiori, he must perceive the same risk in relation to three impeachable serious offenses. Because those could even be criminal offenses, by the way. So the thing about being a respondent is chicken feed compared to what the real, it makes the Busasa so-called risk a Sunday picnic compared to what it is. So there is no way that the president, on his own words, is empowered or entitled to be the suspending authority. He said it to Mr. Hoffman, he said it under oath, So unlike the other thing about saying things in an interview, no. These are things that were said advisedly and under oath to this court. So again, it says at paragraph 29, to page 205, what sets this matter apart and gives rise to the conflict of interest? See now, he's not even talking about the potential. He's talking about an actual conflict. So what sets this matter apart and gives rise to the conflict of interest, on my part, so to speak, is that there is pending litigation that is underway between the public protector and I, which is unlikely to be resolved by the time the proceedings under the impugned rules commence. Again, simply replace the word investigations there for pending litigation. In other words, pending serious investigations on impeachable offenses.
How will the suspension of the incumbent to the office of the public protector prevent the office of the public protector from continue to investigate the president in connection with those 3 incidents that you have highlighted?
Nothing, but that's not the question. Nothing will prevent them. The question is not whether, that's like saying, let's assume the public protector's term was ending next week. Then obviously the new public protector would continue,
Or the deputy?
or the deputy, or anyone, let's say 1,000 other people. That's not the question. The question is what the president himself, I emphasize that, has said, that if, again, let's revert to this, Advocate Mkhwebane, because
If it makes no difference to the president, why would you say there's a reasonable apprehension of bias?
no, it's not me, it's the president. The president says to this court under oath that that question should have been asked to him, not me, when he wrote this affidavit. That why are you saying that if there is this pending litigation, surely you can suspend the person and simply the deputy will be the applicant?
When you say
Right.
he says under oath where in his affidavit?
Okay, that is the 2 parts I've just read to you.
But you
The first
haven't
one
read-
is page 204, my lord.
But you haven't read from his affidavit,
That's what I was reading from, by the way.
from the previous affidavit.
Yes, look at, if you, it's 2 of them, by the way. 192, my lord.
Wait, let me just get it.
Page 192. It's called Second Respondent's Explanatory Affidavit.
That,
And then the next page it says, I, the undersigned Matamela Cyril Ramaphosa, make the following statements under oath.
I'm with you.
Oh, okay.
But this,
So,
this is not, this wasn't this case.
well, it's an oath to God, my
No,
lord.
no,
It doesn't
no.
matter what case
When
it
you
is.
say he made the affidavit in this case, that's why I'm asking. Because
No,
his
I didn't
affidavit
say in this
In
case.
this case is from
I never said
the
that.
300s.
I never said that, my lord.
Okay.
You are the one who said, let's go to the Saldana case. It was in the Saldana
In the
case.
Saldana case.
Yes. So, what I'm saying is that he said it under oath to God, the same God. God was the same when before the Saldana case and now. So he said, I, under oath, make the following statement, that I respectfully say that I accept that a potential conflict of interest arises from the pending litigation. He said at paragraph 29, what sets this matter apart gives me the conflict of interest. That was, my lord, on the 17th. If you go to page 2,
No, I'm
210.
I'm with you. But he also dealt with the conflict of interest issues in the latest affidavit, where the 4 issues,
Yeah, but that's,
in this case before us,
he may or
the
may not
public
have.
protector raised 4 issues.
Yeah.
It's the Bosasa issue, it's the issue of the Zimbabwe plane,
Yeah.
it's the,
So-called judicial capture.
yeah, I'm getting to that
Yeah.
as the last one, and the leaked audio, the Mervyn Dirks
The scope of
complaint.
yes, correct.
Right.
Yeah. But
So-
that's not what I'm talking about.
And then he gives an explanation there. This is now on the founding affidavit in our matter. I know that there were undertakings in some of the previous affidavits. He actually said under oath, I'll delegate if needs be.
Yeah, so I don't
But in
understand what
this
is the
particular
problem now.
matter,
Yeah. In this matter,
let's deal with the conflict of interest issues as it's on the evidence before us in this case.
right. That's what I'm doing. I'm saying to you, to your lordships, the conflict of interest. Remember, okay. Let's go to volume 1, which is the affidavit of the public protector in this matter, as you say, my lord. The public protector simply says, and by the way, unfortunately, it's just going to, it's just sends us full circle. This matter,
Yeah.
page 26. Starting at page 25. Public protector says, in actual fact, the president himself has previously, under oath, that's all, the only point I was making, in an affidavit filed in Part A of the application that was heard by this Honorable Court in October 2020, considered and accepted that a potential conflict of interest arises from the pending litigation between himself and me. In that affidavit, he states inter alia, and then it reads what I've just read to you.
No, this is uncontentious.
Yeah.
It's common
Well,
cause.
That's what I'm saying. I don't understand where the problem is, because that's what she, in this case, in other words, let's forget about the Saldanha case. In this case, she has raised this paragraph 6.61.1, 61.2, 61.3, and 63. In the 61.3, which is the part I had not read, she quotes the public protector. To the extent that the delegation would still be permissible, then it must be made clear that the order operates against me personally and will not affect the authority to delegate the exercise of the power under Section 194.3 of the Constitution to another member of Cabinet who is not tainted by similar conflict of interest. In other words, who is not tainted by similar conflict as me, right? As the court will determine exists in relation to my pending litigation. So whether it's that case or that case or that case, he under oath, I stick by that, he under oath considered to a conflict, which is exactly what is being invoked by the public protector. He is legally disqualified from having anything to do with this suspension. Legally disqualified. We should not even be debating this, because the president himself, I'm not quoting some person or some expert, I'm quoting President Ramaphosa himself. Let me, I'm sorry, Justice.
Let me understand this. All that the relief seeks and all that you saying you want relief for on behalf of the applicant is the letter, the president is prohibited from taking any steps in pursuance of the suspension of the applicant, and the president is mandated to withdraw his letter dated so and so.
I'm sorry, my lord. I'm just going there. Yes. You are on page 2. Yes.
Well, I've got it. So the president is mandated to withdraw his letter to the applicant.
Yeah.
Now, in that letter, it's only asking the applicant for reasons why she should not be suspended. It's not suspending her.
Yes.
So say the applicant had to write back to him and say, dear Mr. President, I refer to all the previous correspondence, all the other affidavits that you made, and you can't suspend me because you are conflicted for the following reasons, A, B, C, D, E, F, G. The President may say, I agree with you, and then delegate.
That's
So
correct.
before you answer, Mr. Mpofu, just maybe for you to give us a complete
forgotten
answer,
your
because there
question.
was an affidavit filed last night
Yes.
wherein it stated that the public protector had already answered to the letter of the President partially, dealing with the conflict issue. So there was a Part A answer. There was such an affidavit
Good.
filed last night.
Then I don't have to answer the question. That's the answer to the Justice Vela's question. He says, say that the public protector wrote to him and say, you are conflicted and so on. But that's exactly what happened. Go to Annexure BMS, I think it's 18. It's the letter written on the...
So my point is this.
on the 22nd.
We may be agreeing with each other. My point is this. Do you still require the relief you seek on behalf of the applicant in paragraph 1.5 of your notice of motion?
Yes, Justice Vela. Why do I seek the relief?
Why do you still receive
Yes, let me explain to you why I seek it.
Yeah.
Okay, there's something called a letter of demand, right? So we write to the President as you propose, okay? We say, you are conflicted, step away. I think those were the words we used. Step away or step aside from this thing because you are conflicted. The President writes back, I'll find you have the annexures. He says, no, you are wrong, public protector. What is that called? A legal dispute. Okay? Because if we write a letter and it says, I remember actually I said this under oath and so on, and I also said it to Mr. Hoffman, then your question would be valid. But we did exactly what you are advising us to do. And he disputes it. That's why we're before you. The three of you must now resolve that dispute between the public protector and the President. That's all. It's that simple.
So show me in the record where he disputes it.
Okay. I think it's the volume.
That is conflicted.
Volume 2. Okay.
Volume 2, you say?
Volume 2, yes. Okay.
His affidavit in this matter is to be found on page 309 and further in volume 4. And he deals with that issue on page 3 to 8 and further.
In his, yes, in
From
his affidavit.
paragraph 28 of his affidavit under heading E.
That's correct, my lord. But no, but
And
Justice
he says,
Vela's
I'm only
question,
going to deal with these 4 issues.
and I'm not guilty or
Yeah.
whatever, yeah. So Mr. No, yes, no, I accept that, my lord. But I'm answering the specific question of Justice Vela. I'm saying that, and he says I'll show him the letter, that we did the right thing. We've been begging these people. We sent a letter to say, please, in the spirit of Section 41 of the Constitution, let us avoid the litigation, do the right thing, and so on and so on. Even yesterday, as you correctly say, 2 days ago, we wrote another letter to the President. We said, please, you said in that letter of the 22nd of March, there's not enough detail about these so-called investigations. Now, the investigations are there. Now you've got the details in the pleadings. Now you've got the benefit of all these quotations from what you said earlier. Please, we beg you, sir, step away from this so that in 2 days' time, which is today, when we come here, all I would have said is, my lords, this case is now going to take 1 day because the President has done the right thing, and he's delegated the suspension.
Well, at the pace we're going, we might still be a Friday and Monday.
And whatever
And that's why I
it
indicated
takes.
to the parties yesterday we're running a continuous
Yes,
roll.
it was also
I'm
with
gonna
that.
sit until we're done,
Yeah, it was. We will.
with no postponements or breaks,
No, there won't
except
be.
for the weekend.
No, we don't want. They must bring it as quickly as possible, but lawfully. So the issue is this, and it was with that in mind, Justice Erasmus, that we made this plea 2 days ago. It was to save you from having to tell me what you've just told me now. And we said, please, you, Mr. President, are the supreme being, or whatever Justice Mkhwebane said in the Nkandla case. You are the embodiment of the Constitution. Forget the Speaker, forget Mr. Janchi. You, Mr. President, have a duty now, having seen all this, to say, I'm stepping aside from this thing, and I will honor what I said to God earlier, that I will step aside from this while it's pending. He refused again, Justice Ville. Not so. Forget the annexure that I'm going to show you now. He refused again 2 days ago. Yesterday, actually, I think. Yeah.
I think Mr. Owen, I just coincidentally he just came on now. It's Mr. Owen in his affidavit, the one that was filed last night, indicated that they were willing to give a further extension on the so-called Part B of the answers, because he's now dealt with a conflict.
Yeah, well, that may well be so. What I'm addressing now is the question as to why are we asking for the president to recuse himself from you. I'm saying that he said at page 271, we do not agree that the president is disqualified for the reasons alleged in your letter. In particular, and then it goes on, and then we explain to him that, sorry, that letter is, it starts at, it's PMS 13B, starts at 268. That was a response to our letter of demand, which is quite detailed about the conflicts, which starts at 258, written on the 23rd of March. Okay? So that was the first letter of demand in volume 3. Yes. Then, as I said, 2 days ago, we wrote him another one, another pleading letter, on our knees again, to say, so it's twice, Justice Ville. Now, the question you were asking is,
You still want the relief
Why?
of withdrawing the letter?
Yes, we do.
The letter be withdrawn.
Yes, the letter, but yes, but
In fact, there's been correspondence since that.
yes, please. I'll explain why. But that's not you may or may not give that relief. Quite frankly, I'm neutral about it. The important issue is that the president must be interdicted from participating in a situation where he's conflicted. How it's framed is no skin off my nose. I'm not, the letter, the importance of the letter, Justice Ville, is simply that, I'll demonstrate that when I go to this issue about the 22nd and so on. Yes. Is that letter is an act of illegality, particularly from a president who knows, what he has said before under oath. And it's also an act of illegality because it stems from another act of illegality, which is the letter of Ms. Nosiviwe Mkhwebane of the 10th of June, which comes from another illegality, which is the meeting of the 22nd of February, 2022. That's how the letters come into the picture. Why do I say that? One day in South Africa, before the 22nd of February 2022, a certain Mr. Richard Janji woke up from wherever he was and decided that on the 22nd of February 2022, he's going to call a meeting of the committee. Just like that, himself alone. No discussion with anybody. I mean, is this a banana republic? No discussion with anyone, no consultation with the speaker, no consultation with the public protector, nothing.
Why will there be a consultation with the public protector if the argument that the process has not started? Should Mr. Janji consult the public protector?
Thank you, Justice Salam. Well, I'm assuming you're asking that question on the basis that the process has not started.
On your version, you
Yes.
say the process has not started.
Yes, I know it's my version, but I'm assuming you're asking that question on that assumption.
If I make that assumption.
Correct. Okay. Well, firstly, if that assumption is held to be correct, the president is still disqualified for that reason alone, but we'll come to that. Why should
Because it's still an internal matter. They can arrange
Yes.
affairs as they feel.
Absolutely, it's a so-called pre-trial. Thank you. That's exactly our argument. Our argument on the second leg is that at that stage, you see, Justice Tolamo, what these people are saying to you is so untenable, and it's demonstrated by your question. You cannot have it both ways. You can't have your cake and eat it.
The same as the PP can't have the cake and eat it.
No, the PP can have 100 cakes because she can plead that he's disqualified. He's disqualified for conflict. If he's not disqualified by conflict, he's disqualified by age. If he's not disqualified by age, he's disqualified by citizenship. If he's not disqualified by citizenship, he's disqualified by gender, whatever.
Mr. Mpofu, be careful, you might land up on TikTok or YouTube.
Yes. No. Okay. That would be not so terrible. A litigant, an applicant, Justice Dolamo, can come here and give you 10 alternative bases.
But it is for the bench to at the end.
Yes.
That's a valid
It
argument.
only needs one.
I'm testing whether that argument is
Yes.
valid.
No, but let's not say she cannot have alternative formulations, because that's wrong. But, so let's come to the respondent. It is the respondent who cannot have the cake and eat it. Because unlike an applicant, a respondent cannot say, such as the president here, he cannot say what you're saying to me, which you are putting for the sake of debate. He can't say, well, if you are saying that the proceedings had not started, then why do you want to be consulted? Because I'll just sit down and go home. No. I understand. But I'm simply...
Mr. Janji wakes up,
Yeah.
calls his people and say, let's take the process forward.
We'll come back to that.
Yeah.
I just want to address this so that it's put to bed once and for all. Because we can't equate the cake. We can't equate the respondent sitting on 2 stools and a applicant who can sit on 100. I'm saying, if the president were to stand up now and say, but Mr. Mpofu, this is ridiculous. You can't say you should be consulted because you said the thing has not started. Then I say, I'll pack my bags and go home. Because on that basis that it has not started alone, the president is disqualified. I'm happy if that's what they say.
That will
So
into my next question that you have packed.
Yes, I'll come to that. So here's the thing, Justice Tolamo. And this goes to, I'll come to your question, I promise. This goes to the heart of this question, of this case, all right? I don't know if, but it goes to the heart of this question, of this case. And that is the fifth case I spoke about in what I call the big five cases, okay? Which is the Mhlahla J judgment.
In this matter, in
this, yes, in the Concord.
Yeah, in the Concord matter.
Yeah. You know, justices, if by now you don't realize that you are being, you know, the smokes and mirrors and mirages, then nothing else will convince you than looking at the judgment of Mhlahla J, paragraph 110 thereof.
That's the one that, just for the record, it's the one that you're asking for the rescission of.
Paragraph 110, which is
A page in our bundles.
in the bundles. It is no. That will be 19.
In our case bundles.
Yes, in the case bundle, my lord, 1988
1900.
and 88.
Don't think I wrote it.
And by the way, yes,
The judgment starts in the 1800s, if I...
that's correct, my lord.
1820, just for the record.
It's 1988,
And you want to go to paragraph
110.
110.
That paragraph, my lord, really makes it obvious that we should not be here, or any reasonable president or speaker or even chair of the committee should not be subjecting us to this process. Right. This is what the Constitutional Court said unanimously. And it goes to your question, this second question, Justice Dolamo. Let me give you background to this. The Speaker and the DA were the appellants, as you know, had asked the Constitutional Court to make the order around the legal representation to be retrospective, or rather, to be prospective. In other words, not to operate as a normal court order, which is retrospective. That is in terms of Section 172B, Roman 1, as you know, that a court may affect the retrospectivity of the order for various reasons. I don't have to bore this court about that. So the Constitutional Court refused to give that prospective order. And it said the order will operate like any other order retrospectively. Are we still good?
Yeah, no?
Okay.
It's just people coming in and out of the platform.
Very important, this context here. So what is then the effect of the retrospectivity of that order? There's two devastating impacts. The first one is on the interpretation. This is what Justice Mhlahla said. The office bearer is entitled to full legal representation at the stage of Section 194 inquiry, that is, during the inquiry before the committee established in terms of Rule 129AA. That answers your first question, Justice Delamo. Why does she want to be consulted, or her lawyers? Because the Constitutional Court of this country said that she's entitled to full legal representation at the stage of Section 194 inquiry, That is during...
At that stage
No.
of the section 194.
Yeah, which is where we are.
Yeah.
That is where we are.
Are you saying it has already started?
No. I am saying the Section 194 committee was established on the 16th of March 2021. That is common cause.
Yes.
Right? That committee had a meeting in July last year. Had a meeting, right? It had another meeting on the 28th of July last year. It had the controversial meeting of the 22nd of February this year. It had a meeting on the 29th of March, and it had a meeting last week on the 11th of May. All right, 5 meetings. Common cause. Okay. Now, the inquiry, and this is why we seem to have I don't know, that's logical or linguistic problems with the other side, yes. And this is where, with the greatest respect, Justice Tolamo, I make this point with all seriousness, that they cannot have their cake and eat it. So it is either they are saying, no, that stage has not been reached for you to participate legally, because we're not there yet. Thank you. If that's what they're saying, then Section 194(3)(a) of this Constitution does not yet apply. Okay? Or they are saying that the thing has actually started. So that could be the. If they're saying that, then they have not complied with the injunction of Mdntv J to give us full legal representation. You cannot have it both ways. It's impossible, with the greatest of the greatest respects. That is the simple situation that these respondents are trying to play around with this court. You can't, there is no alternative. It's either the issue has not started, in which case the 194(3)(a) is not applicable, or it has started, but they've defied, they're in contempt of court, which is a criminal offense, punishable by 15 months these days. So, the
Yes, you rescinded.
unless of course, and then successfully, yeah. As Justice Chapter, whom we miss very much in other contexts, as Justice Chapter said, that should have been rescinded. You are right, Justice Fellow. Yes.
It's 4 minutes past 1.
Yes.
Or 5 past 1. I'm going to take the customary adjournment now.
Yes.
Until 2 o'clock.
Yes, ma'am.
Will the people from the administration just inform the security at the front door that we're starting at 2, so that they allow counsel into the building?
Lord, can I just beg literally for 1 or 2 minutes? I just want to round off this point so that I start with something else. Yeah. Yes. And I'll make it cryptic now, and I might develop it later. So, the answer to all your problems, Justices, lies in paragraph 110 of the Constitutional Court judgment, which, by the way, unlike the judgment of Saldanha J, is binding on you, because it is a judgment of the apex court. So that formulation, what Justice Mkhwebane was saying in normal language, is that I will not make this order retrospective, because, Justice Tolamo, we have not yet, the process has not started. Just putting it here. That's what she was saying. And therefore, your lawyer rights will kickstart when the process has started. What was the date when she said this? The 4th of February 2022. All these respondents tell you that the process started in 2021. They are wrong. And you have no way out of this judgment of the Constitutional Court on that issue.
Is this not the judgment you want to rescind?
Yeah, it is. And so?
No, just asking.
Is that a serious...
That's my question before lunch, Mr.
Yes.
Mpofu.
No, the question is, the answer to that is the same judgment that you told me this morning is final.
No, but what you're saying is, in that paragraph, she postulated the inquiry only to start at a much later date.
Yes.
Because we know as a fact, when the matter was in court the last time, you told us from the bar, and it's now an affidavit, that the so-called charges were only given to her that weekend preceding to the public protector.
Yes, okay.
So she wasn't even served with the charges, so the Audi rule couldn't kick in
Yes.
before the hearing of the last time.
Yes, no, that's correct. But let me just quickly dispose of what you just said now, very quickly, before lunch. I'm assuming that I don't know if you were just on a lighter note.
It was put to you in a lighter note.
Yes, okay. Okay, no, then I won't, because, but if it was serious, we are not rescinding paragraph 110, okay? In the rescission application, we are rescinding the issue about the judge participating in the panel. We can't rescind where we won. We can't rescind the order to do with legal representation. That would be nonsensical on our part.
We'll get to that application in the afternoon.
Yeah.
Because it goes much wider now, the application that was filed,
Yeah.
than merely dealing with, let's call it the judge participation
Correct,
issue.
correct.
It
Okay.
now deals with declaratory relief and so forth.
Okay. Well, before we go to lunch, let me just say I'm happy we are taking that application seriously because that application is the leg that I will start on when I deal with the Section 172(1)(b). Again, we can't have it both ways. We can either say, how can you rescind the rescission and make the ridiculous jokes that are made by pseudo professors out there. Or we can say, no, this is an application by which is to rescind an order, in which case Mr. Masuku will have a lot to say about it, and so will I. But I promise, the last point I want to make is, which so that we round off the pre-lunch things, except that I owe Justice Dolamo an answer, which I will give briefly when we start. Is take page 507, Justice, just to round off the earlier point we were talking about the conflict.
507 of the main bundle.
Yes, that's volume 6, my lord. Just to show you the kind of trickery and dishonesty that we have around this case. Not only did the president make the concessions that I've referred to, but the DA, none other than the DA. We discovered, by the way, that the president, that the DA, this was also some, it's not some put in the speaker's
506.
summary. Page 501.
Oh.
The DA, surprise, surprise, on the 16th of March, the day before the president sent us the letter of suspension, sent him a letter threatening him to bring him here to court, to compel him to suspend. That you'll find at 515. If the president insists on postponing his decision, it should. No. Not that. Different. Yes. No. Just. It should be heard next
It's one of
week.
those long letters.
Yes, it's one of those letters. But the one
It's at page 508,
that's correct, my lord.
paragraph
508, yes.
14 of the letter.
Absolutely, my lord. Accordingly, my client demands that you suspend Advocate Mkhwebane by 25 March 2022, failing which it will approach the appropriate court for relief to compel you to act as the Constitution requires. No outer there. Then, at paragraph 13, they say, which is really, really incredulous. My client is aware that the public protector is currently considering a complaint against you, laid by Mr. Mervyn Dix. It says Dix, it's actually Dex, D-I-R-K-S, MP. In its view, that complaint does not preclude you from suspending Advocate Mkhwebane. The case of her suspension is so overwhelming, and the complaint will continue to be pursued by the Deputy Public Protector, that's Justice Velas one, who will act in Advocate Mkhwebane's position while she is suspended. But if it is your view that you are unable to act because of a potential conflict of interest, then you may ask the Deputy President to, so it's deputy to deputy, you may ask the Deputy President to act in terms of Section 90, bracket 1, bracket B of the Constitution. But the pending complaint against you is no basis to avoid a decision on whether or not to suspend Advocate Mkhwebane. I'll explain the import of that letter after lunch. Because what the DA was saying, which is no longer saying now, it's singing a different tune, Mr. Steenhuisen in his affidavit, was that we know that there's this potential conflict. If you feel that you are conflicted, then you can delegate. That's exactly what we are saying. But now it has been dishonestly changed, the message, to say that there's no ground for such refusal. As the court pleases.
And we will still resume at 2 o'clock.
Thank you, my lord.
Only take a
I'm
45
indebted to
minute
you.
break.
I know I ate into your
The court will adjourn.
lunch.
May the IT please
Oh yeah. Hey, please let's mute. We don't want our consultations to be recorded again. in normal language is, I'm now going to exercise my discretion to suspend you or not. And I'm giving you Audi. I'm giving you an opportunity to influence me one way or the other. Okay? That's really all he was doing. And as you correctly point out, Justice Vele, that principle of fairness is more usually applied in labor law. But fairness is fairness. There's no such thing as fairness in labor law, fairness in this, fairness in that. Fairness is fairness. So in fairness, he decided to grant that opportunity for representations. Fine. So that's the question about the question about the factual situation.
So doesn't that also go to his fact that he's not really biased because he's giving this person such a good opportunity to come and say why I shouldn't suspend you? That goes to the fact objectively to show that he's not biased.
No, it can never do that. Even if
he was biased, he would merely suspend the person.
No, he's not. He might be biased, but he's not stupid, because if he does that, then I mean he would have made my case very easy. The fact that I might want to fire my Leonard Junior, Mr. Shabalal, because he didn't give me a particular volume when I wanted it. The fact that I might be doing that because, not because of that volume thing, but because of something else, because he said something I didn't like yesterday, and therefore I'm biased. The mere fact that I say to him, listen, by 4 o'clock you must give me reasons why I mustn't fire you from this brief, does not mean I'm no longer biased. I'm just giving him a so-called long rope or whatever, or trying to do the right thing, or I might have gone to my lawyer quickly at lunchtime, and they say, no, if we want to get rid of this Shabalala chap, let's give him until 2 o'clock. So the two things are completely foreign to each other. So what is true, Justice Vele, is that, and I mean, we can't second guess the president's motives at this level. What is true is that he was advised to be fair, at least to appear to be fair or to be fair. But all sorts of employers, as you know, Justice Vele, all sorts of employers, biased and unbiased, always give the employee an opportunity to show cause, blah, blah, blah. They might take that letter and throw it into the waste paper basket. That's another matter. But it doesn't, the fact that they've asked for the letter is no antidote for their bias. Okay. Right. So, once then the president grants the opportunity for the Audi, then unfortunately he's bound by it. That should be obvious. So let's make a wild example. Let's say the president gives 10 days, right? Says, in 10 days, show me why I should not suspend you. And then in day 7, he thinks, no, I think I agree with Justice Vele. This letter was not necessary. I'm suspending you right now. That would be sheer stupidity, which I'm sure we cannot accuse our president of. Because he would then invite the retort that you gave 10 days or whatever, and you just woke up one day in day 7 and decided to. No one can then say, no, but the 10 days itself was not necessary. It doesn't matter. He has, as a matter of fact, given it. So that's the first answer to your question. The second leg, which was your real question, was that the letter is not itself a suspension, but a threat of suspension. Right. Let's answer that one. the president I'm looking for. Okay, sorry, I'll find you the reference, Justice Vele. We say in the founding affidavit that the letter of the 17th triggered, and I stand corrected on the actual wording, but the sentiment is what I'm going to say. The letter triggered the suspension process. Very important. Okay? What do we mean by that? We mean that that letter, as we all know, every employee knows, once you get that letter, the writing is on the wall. You can't say you are in the same situation as yesterday than when you've received that letter. That's when people go and see their lawyers. When they receive that letter that says, show me cause in a week as to why I should not suspend you. Okay? All sorts of cases. Gradwell. There's one case, Gradwell, sorry, I'll get the reference, which I did it was about an employee of the Northwest Education. It's one of the leading cases now on suspension. At that point, in that case, once we received that letter, we went to the labor court and said, aha, nobody has given us. Actually, it's the exact opposite. Because they did not give us that letter, we went to the labor court to say, you can't just wake up and suspend us, and so on. So the president was avoiding that kind of thing. But what cannot be denied, Justice Vele, is the fact that, and in fairness to the president, he concedes this in his answering affidavit, that the letter actually kick-started the suspension process. So all we are asking you, my lords, and is to say, the president has taken this step, has kindly given us the warning shot, if you like, instead of just shooting. Please stop him from shooting. Right? So.
But now you're asking for interdictory relief on the basis that please stop the president from shooting. But you don't know whether the president's going to shoot.
No.
Because he may write back after receiving the representations from the incumbent to the public protector and say, listen, I've listened to what you've said, and under the circumstances, I've decided that it's probably better not to suspend.
Yes.
And now you're asking me you're asking this court for interdictory relief on a hypothetical situation that may or may not happen.
No, sir, no. Let me explain that again. We are asking you to stop the president. Let's say, for the purposes of this answer, Justice Vele, assume that the president is conflicted. I'll show you the connection between the two things. What we're saying to you is that stop the president, any president, okay? Any president, anybody actually. Stop anybody in the world from participating in a suspension process in terms of 194.3a for the reason that the proceedings have not started. Okay? So that relief is against anyone in the world. No human being on this earth, unless if they have to change this constitution, can suspend the public protector when the proceedings have not started. Okay? So that's what we are saying to you. But what we are saying more, assume, and that's why the different cake story and the alternative relief. Assume for a minute we're wrong about that. Then we're saying, stop President Ramaphosa. That's a different thing altogether. The first one is that nobody whatever their name is, can suspend before the start of the proceedings. The second one, it says someone else might, or the deputy president or whatever, can do it. But the first one, not even the deputy president or anyone can do it. The second one says, now, court, stop President Ramaphosa specifically from suspending because he as a human being is conflicted. That conflict cannot be transferable to other people, as he correctly says under oath.
But you can't stop him from writing the letter.
No, you can.
You can't stop him.
No, okay.
Let's take away the commencement proceedings, or whether the proceedings are commenced.
Yes.
Let's take away that argument. Let's take away the argument that, talking about the argument of the alleged conflict of the president.
Yes.
He can't be conflicted in writing a person a letter asking for the reason.
You can.
It can't be a conflict.
Okay, let me explain that one. You can't be involved, right? That's the crux. That if you are conflicted, you can't be involved in a suspension process of a person against whom you are conflicted. Full stop. That should be clear to everybody. So the letter is neither here nor there. The letter, the significance of the letter is the fact that it is evidence of his involvement in a matter in which he is conflicted. And therefore, we're saying that letter is ipso facto illegal because it is an act, it's the fruits of a poisonous tree, right? The mere fact that he writes that letter means he no longer regards himself as conflicted, as he says in his letters, wrongly. If he thought he was still conflicted, he would not have written that letter. He would have called the deputy president or someone else and say, listen, remember that letter I wrote to Hoffman saying that I'm conflicted. Now I'm actually more conflicted, the answer I gave to Justice Erasmus. Now I'm even more conflicted because there are now these 3 investigations of impeachable offenses. Please, Mr. Deputy President, write the letter. The reason he did not do that, Justice Ville, is because he considered himself to be legally competent to write the letter. He is not, right? So that's the issue. The simple answer is that, and that is why the relief is couched in those terms, that he must be stopped from taking any further step. And you and I have had this exchange before where I said, even if for some reason you don't give the relief about the letter, and I agreed with you, I still agree with you, that even if you don't give that relief because maybe you don't think it's an illegal fruits of a poisonous tree or whatever, I concede that once you give the relief that says he may not take any further step in this process, the result will, for our purposes at least, will practically be the same. Yes, that I have no qualms with. But that must never be allowed to interfere with the fact that the conduct of the president in writing that letter is illegal. And if it is illegal, when he knew that he is conflicted, and he, well, okay, let's be generous, and he should have known that the process has not started, because that's exactly what he said, then the letter itself is illegal. But, yeah. So, which goes back to Justice Dolamo's question, namely this. The connection between these things, when I say the fruits of a poisonous tree, the poisonous tree is, to go back to that fairy tale I was telling this morning, the origin of the poisonous tree is that Mr. Janchi woke up one day and decided to call a meeting. We stopped at that point, and then we went to the questions about why he didn't consult anybody. But the point I was making is simply this, Justice Vele and Justice Dolamo. I'm sorry. It's this one, yeah. No, it's fine. Go to, stranger things I've never seen. This case stems from what is on page 726. Volume 8, my lord. From those paragraphs, you will see what I call, I don't know what to call it, a litany of illegality. Or to borrow from Mr. Janji himself, a festival of illegality. He spoke about the festival of letters. He didn't know about that other three fingers were pointing at him. Mr. Janji says, under oath, in this case,
What paragraph are you?
21, my lord, says, fifth, the Constitutional Court delivered its judgment on the 4th of February, or rather, after the Constitutional Court delivered its judgment on 4th January 2022, February, I'm sorry, 2022, for the record. Yes. At my instance, just pause there. The Section 194 committee met on 22 February 2022, famous 22-22. Let's just pause there. So, Mr. Janji is telling you, your lordships, that at his instant, not him, not the committee, not anyone, he decided to call the meeting of the 22nd. But it gets better.
Remember, it is after the Constitutional Court has delivered its judgment.
Yes, that's what the 4th of February is.
Yeah.
Yeah, that's
So, on the 22nd of February, when, after the judgment was delivered on the 4th of February, he calls the meeting on the 22nd of February. Was there anything that prohibits him from doing that? Because whatever would have restrained him being a pending matter in the Constitutional Court is our own.
okay. I'll come to that. You'll say, can I read on? It gets better. It actually answers part of your question. He says, on that day, the members of the committee considered the import of the CC's decision. That's number 2. I'll come to that. Let me deal with those 2 first. By doing this, you see, the law is a very exacting and demanding thing, especially if you are exercising not your power as the father of your household, but public power. Mr. Janji cannot, my lord, does not have the constitutional power to do the 2 things. One, to call a meeting as an individual, let alone that actually he was involved in another illegality before, around the so-called suspension of the of the process. We'll come to that. I forgive him for that one because we acquiesced in it. But it was still, it doesn't make it any better. So put that aside. Remember, and I'm sorry to do this, I'll come to the question. At paragraph 20, look at what he says. Mr. Tsinodi MP, who by the way is the star of the show here, because Mr. Tsinodi is, of the three speakers who dealt with this matter, Mr. Tsinodi comes out with flying colors, because it's a pity he was only the acting speaker, because he had at least the right idea. The other two, the less said about them, the better. Mr. Tsinodi MP therefore recommended to me that Section 194 committee holds its work until the judgment the CC delivered this judgment. The old game of spot the difference. What's wrong with that? Mr. Tsinodi was conveying to Mr. Janchi, and later they tried to cheat around this by making it look like it was a decision of the committee. No. Surely Mr. Tsinodi was recommending to Mr. Janchi so that he can take it to the committee and then a decision to suspend the process would be taken. Our Mr. Janchi did nothing of the sort. He says, me, accepted Mr. Tsinodi's recommendation and consequently did not convene a further meeting until after the CC had delivered his judgment. That was not a decision that he could take as I. It was a decision of the committee. But as I say, for that one we forgive him because we didn't challenge it. Let me put it that way.
But who convenes the meetings? The chair, or in terms of the rules, I haven't checked.
Yeah, doesn't matter. It's like saying who convenes parliament. It's the speaker, obviously. But the fact that you are the chair of a let me put it this way: they wouldn't be lying about it now and saying that was a committee decision if he was empowered to do it.
The way I understand the timeline was somewhere in July they had a meeting. This is now July 2020. Yeah,
on the 21st and the 28th. Yes.
That was the last week.
Yes.
Then came the judgment.
Yes.
Then on the 7th of August, the acting speaker filed their application for leave to appeal to the Constitution. That's when the discussion took place in that time.
I know.
When Mr. Chinoli told him, listen, although we called it earlier today the Saldanha judgment, granted you the right to proceed, stop the proceedings, and then he decided, I'm not going to call another meeting.
Yes, but I know the facts.
Until the 22nd.
Yeah, no,
February this year.
I'm saying I know the facts. All I'm saying is the following: on both occasions, that decision can never fall in any democracy that I know of on some single individual called Mr. Janchi. The decision both to suspend and particularly the decision to suspend. They say now, you'll find in this case, they say no, that decision was taken by the committee. It's a lie. That decision was taken by Mr. Janchi, and he says so in so many words. He says, I accepted Mr. Tsinodi's recommendation. Never took it to the committee, never took it to anybody. And I will talk, when I talk about the UDM case, you will see why our constitution doesn't like things like this. Because you can bulldoze decisions just because you are in the majority. But the fact that you are in the, like this decision now where they are saying they are continuing with the process, that decision is so flawed, fundamentally legally flawed. But it stands because, not because it's right, it stands because there are many. So the law is not, doesn't work like that in a constitutional democracy. You can't, just because you are many, if we are sitting here, we say, let's vote that today is Friday. and then it's Friday. No. It doesn't matter how many we are. If what we're doing is wrong, it's wrong. The court, this court, I can't come here and say, my lord, you must find that it's Friday. And you say, why? I said, because we've just voted on it. The court will say, no, Mr. Mpofu, you are out of your mind. Correctly. Because the objective fact that today is Wednesday is what the court has to do, to decide. So,
Mr. Mpofu, I don't put the interpretation that you correct.
yeah.
The committee met.
Yeah.
All he did is got the committee together on the 20th, and then he says, and resumed its work.
Yeah.
So he's talking about the committee resuming the committee's work, but he merely got them together.
Yes.
It's not saying that he took the decision. He took the decision to get the committee together. The committee then took the decision to resume the work. What's wrong with that?
Okay. Who took the decision that the committee must meet on the 22nd?
He says that my instance,
Exactly.
the committee met.
Yes, on the
So he
22nd.
called it together. He said, you, we must all come together, we must have a meeting.
Yeah.
The committee then decided to resume its work.
Yes.
That's not the person who convened the meeting deciding to resume the work. It's the committee.
Okay, I'll try and do this. At that point, Justice Vele, we know that the activities of the committee were suspended, all right? Right, okay? Voluntarily.
To await
Yes.
the outcome.
Well, even on the outcome first came on the 4th. Let's assume he did this on the 10th, okay? Even then, the proceedings were suspended, ipso facto. That's a fact, okay? What he did was to unsuspend the activities of the committee. Admittedly, as Justice Vele points out, to convene them. But the point I'm making is a much simpler one. It is not his place, right,
Unsuspended.
to unsuspend.
Because it was voluntary. They suspended the proceedings because they
No, it was not voluntary.
necessary to wait voluntarily.
It was not voluntary. No, it was not. That part, the voluntary part is that they did not resist the recommendation of Mr. Tsinodi. But it is not as if, Justice Dolamo, they woke up and said, there's an appeal, and therefore we're going to suspend. It's not that voluntariness. It actually shows another lie, where the speaker, abdicating her power, says that it is not her baby to suspend the proceedings.
In whose jurisdiction does the 194 process lie?
In the speaker.
Committee.
It's the speaker's subcommittee. It's a subcommittee of the National Assembly, right? So the speaker, put it this way, Justice Dolama, his point is simple. What Mr. Tsinodi, that's why I praise him so much. What Mr. Tsinodi did was his job. He knew that the committee is not a fiefdom of Mr. Gandhi, but a committee of the National Assembly, which is the answer the question you are asking. And hence, not Mr. Gandhi, Mr. Tsinodi, the speaker, took the initiative to say to the committee, as the Makulubas, the custodian of the process. He says, listen here, and he gives the most beautiful explanation. I'll come to that at paragraph 97 and 98 of his affidavit. He says, I know, as Justice Erasmus just said, I know that Section 18, we would have had to go and do a Section 18.3 application and what have you. But I didn't need that because, one, if the judge was wrongly appointed in the independent panel, then the whole thing is invalidated. But here's the most important part. He says, even if that judge thing is not, you'll find that at 10:38. And in any event,
it's also summarized in Mr.
In
Judge's
Mr. No, it's the Speaker's affidavit. You'll find it in the Speaker's affidavit, 10:38.
It's in Mr. Janchi's affidavit as well, on page 725. 725. It's where you were earlier. Just
oh yeah, just a page before.
Paragraph 19.
Yes, no.
Summarizes that.
Yes, no, I don't want that version.
That comes from 97 and 98 of
Yes.
Senoli's affidavit
Yes.
in the Concord.
Correct. No, I don't want that secondary thing. I want the verbatim words of Mr. In the Speaker's affidavit, it's quoted verbatim. This is what our glorious Mr. Tsinodi said. The reasons for my recommendations are the following. Let me start 197. Third, although the making of the present application for leave to appeal directly to this honorable court and of the conditional application to the full bench for leave to appeal to the SCA, which is another important thing that gets ignored, that they postulated, by the way, further litigation. The fact that that litigation happens to be now in the form of a rescission and not an application to the SCA is neither here nor there. But anyway, for leave to appeal in the SCA will suspend the operation, see section 18. I have decided, not Mr. Judge, I have decided to recommend to the section 194 committee, again, not to Mr. Judge. That's why I'm saying when Mr. Tsinodi was making the recommendation, he expected Mr. Janti to do the right thing and call a meeting of the committee, which he didn't do.
So he says, I recommended
to Mr. Janti.
I directed Mr. Janti to cease any activities of the 194 committee. But I think we moved too far away from what I wanted to find out from you about the letters. But continue.
All right. So he says that he recommended as the Speaker to the committee, which is how Speaker, who is the custodian, as you correctly asked the question, recommends to the committee.
Yes.
All I'm saying to you, Justice Dolamo, is that surely, what that means is that Mr. Janki should have then called the meeting of the committee. That's what he says here. I recommended to the section 194 committee. All right?
But it's Tsinodi.
Yes. Okay. So he was recommending to the committee, but he couldn't call a meeting of the committee himself. He called the chair so that he calls the committee. The committee could have said, we don't agree with that recommendation.
Exactly.
All right? So once you accept that, then you accept ipso facto that that was a decision not of Mr. Janki, but a decision of the committee.
The committee is established as a committee that has to do with the 194 process.
Ad hoc committee.
Right, ad hoc committee. And that committee is chaired by Mr. Janki.
Correct.
The Speaker is not an ex officio member of that committee.
Correct.
It operates on its own in terms of the rules that they have agreed.
Correct.
So it can call its own meetings. Isn't
Correct.
It?
But it did not. That's the point I'm making.
What does 21 say?
21 says that, no, that's a different thing. That's 6 months later. We're jumping ahead. 21 talks about February 2022. No. Yeah, so that's a different matter altogether. I'm saying that in August of 2021, forget about 2022. In August of 2021, Mr. Janji took a decision, accepted a so-called recommendation, alpha virus, where that decision should have been taken by the committee, one way or the other. You and I have agreed, Justice Dolamo, that the committee could have said, we reject Mr. Tsinodi's recommendation. Let's go the Section 18 route. But that decision was not taken to the by the committee one way or the other. It was taken by Mr. Janji. He says so in so many words, right? And then he says that the process which is currently underway in relation to Advocate Mkhwebane be suspended pending the outcome of the present applications for leave. If leave is granted, the decision appealable to this honorable court or the SCA, as the case may be. In other words, it could be a long suspension for years and years if it goes to the SCA, or it could be a short one. Because remember, what he was postulating here is that it might go to the SCA and then go to the Constitutional Court. I'm quite sure by now it would not have been resolved. The Constitutional Court, of course, we know, gave direct access. That's a story for another day. Nobody knew that at this stage. So, and he says this, Mr. Tsinodi. The reasons for my recommendations are the following. It would be inimical to the proper legal or rational performance by the National Assembly of the duty of great importance imposed on it by Section 194, for it to proceed with the current process in the face of the order by a full bench of the High Court invalidating parts of the 129V, that's the one about the judge. If confirmed on appeal, will invalidate everything in that process from the date when Justice Nkabinde was appointed to the independent panel. Let's just pause there. What Mr. Tsinodi is saying correctly is that if the appeal on the judge issue is upheld, this will invalidate everything until that point. Again, I'm just guessing. Step 3 of the 17-step process, whatever it is. Yeah. Okay? But here's the real issue. He says, moreover, even if the appeal against the order concerning 129V is ultimately successful, and here he was being prophetic, it was successful, the Section 194 committee is on the point of proceeding to hold proceedings, or rather to hold hearings. And here's the catch. He says, the proviso to Rule 129AD3 will preclude, that's the one that the Concord ultimately agreed with us on, will preclude any legal representative who Advocate Mkhwebane may appoint from participating in the committee. At paragraph 229 of SARFU, the logic should tell us, I mean, as I said, I don't know why this point is that's the point I was saying, doesn't need a law degree. It says, the Constitutional Court said, terms of reference constitute a mandate, right, for the commissioner, which he or she uses as a guide to determine the scope of his or her investigation. Consequently, the question to be answered is whether objectively, the terms of reference are reasonably comprehensible. They make a different point. But from that dictum, Justice Tolamo, I'm saying there is a different ground altogether to everything we've said about 110 for you to find. It's the same thing. You have no choice in the same way you don't have a choice in respect of 110. You have no choice but to find that it is absurd to suggest that proceedings have started when you don't have terms of reference, let alone not having evidence leaders. It's just an absurdity. So I'm just using that as insurance to peg the ridiculousness, if there's such a word, of the notion that the proceedings had started, away from the 110 point. So what am I saying then, Justice Dolamo? I'm saying three things. I'm rounding off now this, because this, with the greatest respect, judges, Justices Erasmus Dolamo and Justice Villa. If, and we were at pains to say this in both in the reply and in the founding affidavit, if this court, for some reason, misses the point that you are raising, and that's why I'm addressing it so much, of the intersections between these two things, or between these three primary respondents, then I'm afraid we would have missed the boat. If it is not clear, or made clear by me at least, that what the continuum is between the meeting of the 22nd, the letter of the 10th, and the letter of the 17th. If I fail in my task to explain the connection between those three things, then I will have failed dismally. Because those three things, as I say, lead to the other, and they all are the fruits of the poisonous tree, which is the incorrect majoritarian. UDM makes it very clear. That's why in UDM, with Mr. Badlander, we said, by the way, all the 5 cases of the big 5, I was in those cases, and how they knit together is the following. In our system of democracy, we cannot, and this is a proposition that was accepted by the Constitutional Court in UDM. All those cases were decided unanimously in our favor. Only the impeachment case, we only won 7-4. It was the most difficult. In fact, I have a story for another day for that. But the relationship between those cases is simply the following. We have moved away from a majoritarian system. We are in a system that is about the rule of law. And therefore, unlike under apartheid, the fact that you might have the numbers in parliament does not mean that you are legally correct. Remember, under parliamentary sovereignty, the mere fact that you have the numbers means you are right. You can make the example that I was making earlier. You can decide that it's Friday today, and that it will be Friday. But in a constitutional democracy, it's not like that. There's something called the rule of law, which is the courts, in their own right, saying, yeah, you might vote and say that it's Friday, but we're telling you it's not. And the final word will not be the one of Parliament, it will be the one of the court. Now, that's what the supremacy of the Constitution means in the simplest terms. A supreme justiciable Constitution, which means determined by judges, to put it simplistically. Now, so therefore, if this court were to sanction by default or otherwise conduct such as the one we've described here, which is illegal because it breaches the Nemo Iudex rule of conflict of interest, conduct which is illegal because it breaches stare decisis rule, which is that you are bound by 110. Conduct which is illegal because we were made to, I don't know, a mind twister to say that there was a process or proceedings which have started, but the terms of reference were adopted later. I mean, really?
When would you say, because you only have 20 minutes left,
Yes.
when would you say the process would start?
Yes.
The,
Thank you.
Alla the Constitution Court's words, the inquiry,
Yes.
and whether the inquiry and the proceedings
It
is to be
Yes. Yes.
interpreted the same.
Yes. Thank you,
Because
Justice.
you make, in your founding affidavit, you actually postulate a date.
Yes. No, but please.
But that date has come and gone in any event.
Yeah, no, it hasn't, actually. It hasn't. Every time you see the words in the founding affidavit for May 2022, scratch them out and put 11 July 2022.
Yeah, no.
Okay? So, no, try and explain this. The only reason we postulated the start of the proceedings at worst on the 4th of May, which you correctly point out, Justice Erasmus, has come and gone, and quite frankly, nothing happened. It was all that Mr. Abramji was wasting his time. Yeah. So the reason that date of 4 May, now, according to the latest program which you have, which came from the 11th of May, is literally on the 11th of July. Yes. But life, you see, the Constitution didn't say you may suspend on the day that it is likely that the proceedings may start. Why? Because it wanted to protect the public protector from exactly what is happening now. Because that date can be shifted for very valid reasons, let's say. And then she will be suspended and her rights will be violated in the process. The Constitution deliberately says it must happen after that date. That must be surely, because the founders of the Constitution wanted to protect a person in the position of the public protector from all sorts of COVID-19, whatever happens, which might delay the thing. Just in the same way, Justice Erasmus, that a suspension of a judge in terms of 177.3 is upon the JCT, the structure of the JSC called the JCT. Remember, there's a JCC, which is the first committee. And then the matter goes to the JCT. And then from there it goes to something called the small JSC, which is the JSC minus the MPs. So the founders of the Constitution said, deliberately, to protect our judges from the calamity of a suspension. They said, no, the fact that you might have a complaint and that complaint goes to the JCC, and even the JCC finds that it should go further, is still not enough to trigger a suspension, right, of a judge. One can say, but how can you, mothers and founders of the Constitution, say that when even the JCC process has now concluded and found that there's prima facie evidence, why can't we suspend? No. The mothers and founders of the Constitution say no. You have to wait only upon the JCT finding may you suspend. Doesn't matter how strongly you feel about it, or that the judge is accused of killing 1 million people or whatever. The suspension can only be triggered at a particular point. And I've explained to you linguistically that with the holders of public institutions, it must be assumed logically that the protection that is given to holders of Chapter 9 institution, heads of Chapter 9 institutions, it is at worst similar or better than that of the judges. And in another, if I ever write an article about this, I would say that it's better, but I'm happy to say it's the same. And I say that because the word after makes it clearer than in the question in the case of a judge. Makes it clearer that the judge is protected. The word upon in the case of a judge means it doesn't matter how many postponements the JCC or even the JCT can have. Only when it reaches a particular point can you do this. And we know that it can take many years for those to happen. Similarly, the founders and the mothers and fathers of the Constitution were saying the same thing. It doesn't matter, let's say the panel, there's a problem, and then somebody gets sick, or they die, or whatever, or there's COVID-19, and all sorts of things happen. You can't say, hey, we're tired of this now. There have been all these postponements of the independent panel, or it gets dissolved and reconstituted and challenged, and the stories we were saying this morning. What if, what if, what if? It doesn't matter. The Constitution is very clear, and nobody knows that more than President Ramaphosa. He said it to Mr. Hoffman, that Mr. Hoffman, my hands are tied. I cannot suspend unless the process has started. He knows this.
Yeah, that's why I'm asking you. Forget about the dates.
Yes.
At what stage of the development of the process, the
Yes.
17 steps, if one want to call it that,
Will the
you
proceedings
say
start?
the process
Okay,
starts?
the short answer is I don't know. The long answer is that at worst it will not be before the 11th of July.
That's when the evidence is presented.
Yes, that's when the presumably will be invited. That's when the judgment of the Constitutional Court hopefully will be obeyed. Because that judgment must not be looked at skewly. That judgment said full legal representation. When the process starts, you must have full legal representation. The only reason, Justice Erasmus, that we have not been invited to the meetings of the committee is because they know, they're just lying to you. They know that the proceedings that Justice Mkhwebane was talking about have not started. Otherwise, they would have invited us. Because full legal representation is full legal representation. One doesn't need to be a genius for this. If you say I have full legal representation rights in the CCMA or whatever, then how can the CCMA proceed and do all sorts of things without me or my lawyer? It can't happen. Full legal representation means wall to wall, right? It means from start to finish. So that's what I was trying to explain, that these people are trying to fool this court because they cannot have it both ways. If they genuinely believed that the process has started, then they would have had the lawyers there. It would be us who say, no, we don't want to come because the process has not started. No, they know in their heart of hearts, everybody knows, everyone should know. It is very clear, and that is why they have not invited us. They know that the proceedings have not started, but they're jumping the gun because they want to suspend this person by hook or by crook, and mostly by crook. So and this is where we keep on going back to this 110 story. If on the other hand, let's be generous, they genuinely believe that the proceedings have started, as envisaged in section 194(3)(a), then they are guilty of even something worse, which is contempt of court, which is plainly illegal. Because they then knowingly are depriving the public protector of her full legal representation, knowing full well that the apex court has ordered it. I don't want to put, that one is too ghastly to contemplate, as one PW voter once said. But, and I don't even want to go there. But those are the only two options, Justice Erasmus. There's no other option, with the greatest respect, that is available to these parties. And therefore, to round it all up, the public protector is only saying to this court, please, court, all these people are descending upon me, including the Abraham G's of this world. And as Justice Chapter said in the impeachment case, oh, sorry, just something. Okay. Oh, I'm sorry. I just missed something. Oh. Yes. The test is postulated for all these things I've said at paragraph 171 of SARFU. And it is simply this. Forget the conspiracy theories about coordinated attack and all that. Even if the president genuinely but naively accepted that, as he says in his affidavit, well, what do you expect me to do? I got a letter from the speaker saying the thing is resumed. Well, firstly, that's just a lazy approach to these matters, because the president can't do that. He can't simply say, well, I got this letter and therefore I want to suspend you. I didn't scrutinize the letter. I didn't take my own view. That would be illegal on its own, just for another reason. But the point I want to make, which is made in SARFU, is that it doesn't matter even if he genuinely did that. The test is objective, which is what you and I, Justice Delama, has been saying. Have the proceedings started or not, objectively. Not what the president thinks, or not what is worse, what the speaker thinks, or not what Mr. Janchi thinks. And this is what the Constitutional Court said. The legally relevant question, it was a question of whether it was an interpretation point, like here, was whether the meaning of the words matter of public concern. And here you can just transplant those to mean the starting of the proceedings, blah, blah, blah. To be applied is an objective one. The legally relevant question is not whether the president thought that the subject matter of the inquiry was a matter of public concern, but whether it was objectively so at the time the decision was taken. Whether or not the matter is one of public concern is a question for the courts to determine, and not a matter to be decided by the president within his own discretion. In this context, the Constitution requires that the notion public concern be interpreted so as to promote the spirit and purport of the Bill of Rights and to underscore the democratic values. We all know that. That is in terms of Section 39(2). And what the full court was saying there was that It matters. It matters for us because we are accusing the president of a coordinated thing and so on. But if you are not with us on that, that does not matter for the outcome of the case. Because even if the president, in his heart of hearts, honestly, he can swear that all he did was to pick up this letter and assumed, rightly or wrongly, that it was telling the truth. Even if he can show that, that's not going to absolve him from these kinds of proceedings, because it's not about his state of mind, it's an objective test. Now that, if I'm sorry, I'm trying to race against the clock.
If you through with this,
Yes, I can take another
I
question.
have one aspect that I would like to hear you because I see you running
Yes,
out of time.
Thank you.
That is paragraph 1.2 of the notice of motion,
yes,
where you say the section 194 committee must be prohibited from performing
any further function.
any further function.
Yes,
That relief, you, for the moment, let's put aside the letters written
Yes,
by the
yes.
President and the Speaker. So,
Yes.
you can only be entitled to this relief if you convince us that we have to pause any further activity pending the outcome of the recent
Decision.
application for rescission.
and declarator. No, that's incorrect.
What else can
Okay, I'll tell you what else. The relief, first and foremost, is the normal relief. I'm sure it's the first time you find a party that is in a rescission application. So the relief, first and foremost, must be seen for what it is, the usual thing that you, Judge Saldana and all sorts of other people and all our courts in Part A and Part B. It's the same type. It's pending, not some rescission, pending Part B, right? So that's the first thing.
Pending that, that's one aspect that we need to consider.
Yes, I'm saying firstly, Justice Dolamo, you must, let's call the rescission Part C, okay, for ease of reference. So the relief that is sought is pending Part C, yes, we are right, but it's also pending Part B. If you go to page 1, I don't have it, but
I don't want to short circuit your argument. Part B, when I read the prayers, you are saying we will have
the
to
declaratives.
Yeah, declaratives.
Yes.
We have to look at that. But everything else hangs around whether the rescission, you say, once it is noted, that's the end of the story. Well, that's another debate.
No, I'm sorry,
So
Justice.
we must wait
No.
to see that process unfolding.
No, thank you. I'm glad you've asked that question because it gives me an opportunity to clarify two things. What you are doing, Justice Dolamo, is to conflate the relief sought in prayer 2 of the notice of motion, which is the one that is directly linked to the rescission application, among other things. Assume for a minute, how can I put this? Assume there's no paragraph 2, okay? And then assume there's no rescission for a minute. Then I would be here in any event in front of you saying what we say in paragraph page 1. Pending the finalization of Part B, right? Nothing to do with any rescission or whatever. Granting the interim prohibitory interdict and mandamus for an order in the following terms, blah, 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 blah. That's it. Forget about rescission, forget about any Rule 45A and all those things. The relief that is why the fallacy, or what Mr. Justice Cameron called the bogeyman of separation of powers harm, which is used as a scarecrow for courts not to do their job. That's where it comes in, because Part B, in its own right, it doesn't hang on some decision or whatever. Part B, in its own right, seeks relief. It is the picking, the target of the picking, so to speak, that was spoken about in EFF versus Gordon. We say, among other things, outer does not apply to that relief, to the relief, even in the normal Sitlugelo sense of the word. We say it doesn't apply because Part B, in this case, is not a review application. Outer says in so many words, Justice Musaneke explained in outer that the outer principle is with regard to reviews. So that's the first exception we say, why we say outer doesn't apply. To Part B, forget about Part C. Then we say outer also does not apply because the decision, all these things we have spoken about this morning, about suspension, terms of reference, and so on. Those are not the so-called polycentric policy decisions, which outer warns us about. Because outer applies when, and that's what the point that is made by Hoekstra in the passage that I cited in my head. Hoekstra, unlike me, is more radical in the criticism of outer. She says both outer and EFF versus Gordon just create, what does she call it? A license, so to speak, for impunity. I can't remember the exact word here. Because all sorts of rogue public officials, whenever they are found out, when the court has to say, don't do this, oh no, outer. You can't interfere. It's the exercise of my. She says outer was not meant for that, and she is right, Professor Hoekstra, because outer was meant to insulate the executive, not from unlawful conduct such as the one we have explained this morning, of conflict of interest and so on, but from the courts usurping the powers which are circumscribed in terms of the separation of powers. So that's the second reason. The third reason is that both the judgments of Musaneke J and Froneman J said the following. I can't remember the paragraphs now. At different parts, that outer, the outer test of the clearest of cases, what applies if you do not rely on other fundamental rights, right? In other words, if you are saying, let's stop this public authority from exercising its power because I'm aggrieved by this and that and the other.
I didn't want to interrupt you when you are on the road.
Yes. Thank you.
Yes, because you also run out of time.
Yeah. I said, assuming the letters, President asking for a representation for a suspension decision is made, assuming we are with you, we say the President should not have done that.
Yes.
We can only talk about moving to Part B if we say you have, I don't know, I don't want to call it prospect.
Yes, if you pick, it's called likely to succeed.
Yeah.
If I'm likely to succeed, yes. Yes, I
If
agree.
we come to the conclusion, having removed all these other
Yes.
things, if we come to the conclusion that you are not likely to succeed.
Yes.
So therefore, you will not be entitled to 1 or 2.
No, but I'll be entitled to 2. That's the point I'm trying to make. 2 has got nothing whatsoever to do with with the likely to
But
succeed.
2 then, would that be academic, what you're asking for in B?
Yes, that's why it's called an
Academic.
no.
So,
Justice
a
Del-
lot of practical importance.
Yes,
to
of course.
To the applicant.
Yes, of course, Justice Dolamo. When a litigant pleads something in the alternative, it means if you find for us on the pure Part A, Part B, you don't need paragraph 2. Why? That's why it's called in the alternative.
I'm saying,
So, which means if then it will not. You can throw it in the dustbin, because if you find for us in relation to the normal Part A, Part B formulation, then that's the end of it. But in the alternative, if you can't see your way clear to find for us in relation to Part A, Part B, because of outer or whatever reason, then only then does prayer 2 kick in. Okay. So it's an alternative basis. I think it says that.
again, I say, part 2, even if it's in the alternative, it depends on the rescission application.
Yes, but that's
Right.
exactly what I'm saying.
If you don't convince us on the prospects of the rescission application, can we still talk of part 1.2?
Yes. For the same reason that I've just explained. Let's go to page 3 of the notice of motion. Let's go to page 3 of the notice of
Yes,
motion,
okay.
Justice Dolam. And by the way, I know the presiding judge had said I won't be interrupted. I welcome these interruptions. Let me just say that, because it's very important. It explains things that.
For once you've done, you have to wrap up, because
Yes.
you're going to get an opportunity to reply.
Yes, of
so
course.
that we can do Advocate Masuku also this afternoon.
Yes, but
Because
can I
you're
answer
way
the
over
question?
your time limit of this morning. We've actually given you double your time. I'm looking at the clock there, it's 8 hours and 4 minutes.
Well, that's wrong.
No, I have to take out the
it's-
postponements for the
yeah,
adjournments.
but anyway,
But,
no, everyone does that, but that's wrong. The reality is that you said at 9:30 that after we did the formalities, we start with the the running.
No.
Yeah. So there's no double.
But-
I know that it's beyond the time.
We agreed at lunchtime that 4 o'clock was going to be the
Correct.
cutoff.
That's a different matter. Yes. But there's no double
Okay.
anything. All right.
So wrap
So the answer, Justice Dolamo, lies in the first line of page 3. If you read that, it says, and we did this exactly to circumvent this kind of approach. Pending the finalization of Part B and or the rescission application. All right? So again, it's the alternative. If we had said there, pending the finalization of the rescission application, then your question would be appropriate. Because you would say to me, yes, insofar as the rescission application is concerned, if we're not with you that any order can be rescinded, the debate we had this morning, then Mr. Mpofu, you have to consider, and I would have considered, that that relief would go. But that relief is not pegged on the rescission application only. It is pegged on the alternative, Part B primarily,
Right.
and then in the alternative.
Now, I'll say Part B, of what relevance does it have to the applicant? If, for example, the development of the common law, if what he is asking this court to look into is so that we hold in abeyance the execution of the judgment pending the rescission application. So if you say the rescission application is not going to be off, it's unlikely to succeed, do we still have to develop the common law, and for what purpose?
Okay. But, firstly, I did not say, I said the exact opposite in the morning. I read from Erasmus that the prospects of success of the rescission application are irrelevant. I read it here. It was 560 D1.
Yes,
560.
I heard what you said.
Yes.
And I'm saying
Yes.
it will be another debate.
Okay.
But if we
I get it.
if we say we are wrong,
Yeah.
we say
Wrongly.
wrongly.
Then
we
we'll
say-
appeal. But
Wrongly, we
like
say that we don't see any prospects in the rescission application. Do we still have to deal with Part B?
yes, Justice Dolamo. The Part B.
Yes. No, I'm saying, why should we, it's not before us, why do we still have to say we grant you 1.2 pending Part B?
Right. Because if when you pick into Part B, you find that our case on 1.3 of Part B, which is that declaring in terms of Section 172(1)(a) of the Constitution that the conduct and or decision of the committee to commence and or proceed with the Section 194 removal proceedings while the matter is subject to care to be unconstitutional.
Subject to care because there's a rescission application.
Yes, subject to care because there's a rescission application. Or if you go, and that is just for the committee, right? But if you go to 1.2, the conduct and or decision of the president in initiating and or pursuing the suspension against the applicant to be unconstitutional, rational, and so on.
And if we say the president is wrong,
Yes. Then you must. Then when you pick, you will say, if he's wrong now, he can be right
it
later.
can't be right in
Yes.
Part B.
Yeah.
So why do we go to Part B? Why do we, even if, I'm not saying this court, why do we grant a suspension or an interdict for a Part B which is going nowhere?
No, it's not going nowhere. It's the question is whether it's going to succeed. It's going somewhere. That I can assure you.
I'm
It's
saying
going
if,
to.
if this court today,
Yes.
because in Part 1 you say 1.3 that you are taking the president's right
Yes.
to issue the letter.
Let's say it's 1.2. Yeah.
Yes. If we say to you, you're right, the president should have done that. Do you still have any entitlement to say Part B must proceed because I want to go on with 1.2?
Yes.
For what purpose?
Yes. Justice Dolamo.
I want to know.
Yes. No.
Enlighten me.
No, I will. Every day in our courts, people ask for interim relief, pending the main relief. Whether that main relief is a defamation or whatever, okay? All I say to the court in Part A, Judge Dolamo, please grant this interim relief because I'm being defamed and I cannot wait for the defamation action. That is Part B. All right? Now, the court cannot say, Mr. Mpofu, why should I protect you from the defamation now? Or,
Defamation may not be
no, but it can be anything.
Let's take a practical example in this context. The president says, you're right, Mr. Mpofu, I should have issued this letter because the process has not commenced. I'm withdrawing those letters.
Yes.
So what is remaining now?
No, then, of course, there'll be no Part B, of
Right.
course.
Then
That's the
there'll be no
point.
Part B. So I'm saying, if these other things falls off, will we still be entitled to 1.2?
Justice Dolamo, there is a world of a difference between a president whose stance you've just postulated now, which is really but why we wrote in this letter 2 days ago, who says, okay, I didn't look at it that way. I've now listened to Mr. Mpofu or to the court or whatever, and I'm out of here. I'm giving this to the deputy president or whatever. Then how can we in our right minds come to the court in Part B and say, stop the president from doing, no.
That's precisely the
There is a
point.
difference between that scenario, okay, to the current scenario, the real scenario, where the president stands, as you and I know it now, is that he is not conflicted, and that he will fight to the bitter end to protect, which he has done twice now. He did it in the letter of the 25th of April, I think, and 25th of March, and in the letter yesterday, when we asked him again. There's a world of a difference between that president, President X, and President Y. President X, which is the first example, clearly that would be the end of the case. But President Y, not President Y, President Ramaphosa, the real issue here, whose stance known to us and the court right now, is that all this is just the proceedings have started as far as it's concerned, and he's not conflicted. That's his stance. Until he changes that stance, Justice Dolamo, Part B is going to happen. If, however, and that's just a big if in the world of speculation, whether it's the president or the speaker or whoever, if the speaker says, Mr. Mpofu, that letter of the 10th of March, I should not have written it, then why would I continue with Part B? But as we sit here, that is not what is in front of you. As we sit here, you have affidavits this big saying, no, there's nothing wrong with the process. The proceedings have started, and now, so honestly, I can only go on what they say under oath. If their stance changes, I don't know what we might do, to be honest. Yes, but the last word on this is this, and I thank you again, Justice Dolong, because you gave me an opportunity to deal with the outer point as well. But this court is in the same position. I think Mr. Breitenbach was my opponent again. In the Delil cases in this court, it was exactly this kind of debate. Because, as usual, as all sorts of respondents do, when they don't know what else to do, they invoke outer. And they said, no, Mr. Mpofu, you cannot get the relief. I think it was Judge Henny, I can't remember now, but there were two sets of judges. The first one was Judge Samela and someone else, and then the let's call it the interim interdict court. The interim interdict court said, despite all protestations by the respondents, because, which is the discussion we're having now, because this case is slam dunk, that Part B, it is clear that the DA or the municipality, I think was the respondent, has violated the rights of Ms. Delil. And as they were proven right, it is likely to succeed in Part B. Therefore, we are giving you the protection as the judges of this country. We are giving you the interim protection, outer or no outer, because that is our duty to between now and then. There was going to be some vote, I can't remember the facts now. And indeed, the court granted us the relief. We then came back, Justice Dolamo, for Part B. If that court had said, well, Mr. Mpofu, what if the municipality changes its mind or comes to its senses? Then I would have given them the same answer I'm giving you. Say, we're not going to come back here. But because the municipality maintained its stance, we came back for Part B, and we were successful in Part B as well. So that's the short answer. So this court, we implore this court to follow the example of what it did in the Delil cases by accepting that if the illegality, let's assume you were right, Justice Dolamo, if you say, look, there's no way out of this 110 issue, or there's no way out of this terms of reference issue, or there's no way out of the conflict issue, then it means whether you apply the strict outer test of the clearest of cases or the more nuanced one in Godan of likely to succeed, then you have to grant the relief. That's really all we're saying. Based not on some rescission or whatever, based just on the law. Remember, in Delil there was no rescission. So let's not conflate the two things. Based simply on the likelihood to succeed in Part B, simply, then you will be constrained to give me the primary relief in paragraph 1. If, however, you don't agree with that for some reason or another, remember you even have a discretion, then only then does paragraph 2, which is the alternative, kick in. That's Rule 45A. Then we can start talking about rescissions and those kinds of things. It is that simple. We have to postulate notionally that there's no rescission, there's no paragraph 2, there's no Rule 45A. This is just a normal case that happens in every case in the land where you have Part A and Part B, and deal with it on that basis. But even when you do that, and otherwise I wouldn't be wasting your time talking about the inapplicability of outer. The reason I'm doing that is because I'm assuming that you will decide the case on the normal basis. Otherwise, I would just say, I don't care whether outer applies or not. But I can't do that. That would be irresponsible. I have to assume that you say, no, forget the rescission, forget the Rule 45, forget whatever. Let's just look at this case in its normal and pick through, and in those, as the case, the Delil case courts did, can I grant the relief? That's all. That's all.
You're done, Mr. Mkhwebane.
Yes, but
I allowed you to go on because you were answering my brother's question.
Yes, yes. No. I'll just a minute.
Because you can deal with any other issue in detail in reply.
Okay. Let me then just refer you to. I won't go to those cases.
No, you can give us. You gave us a list.
Yes. No.
Of the top
outside
5.
of the list.
But give us the cases. You've got 5 minutes. Give it to us. Otherwise, you can drop us a note on the cases.
No.
Because you prepared substantial heads.
Yes. All right. The first case is Mwelase and others. This is Director General for the Department of Rural Development and Land Reform and another. 2019 6 SA 597 CC. The second case is Doctors for Life. Okay, that's a well-known case. I'll give the reference at some future time.
Yeah.
The normal, the usual Doctors for Life case. Then the third case is Amabungana, which is part of the list.
Yeah.
Yes.
He's in a bundle.
Yes. And the TAC case is also in your bundle.
Good.
Yes. And then I will give you the right paragraph in the EFF impeachment case about this proposition. And the proposition, before I sit down, is simply this. The courts should not shirk from their responsibility. Those are the words of Justice Cameron. Simply because there's this, what he called the bogeyman of separation of powers. Because as you know, Justice Erasmus, what was said in TAC is that it's so simple that it almost hurts. It is that only the courts, so there's no question of intruding, only the courts are mandated to make the kind of finding that we're asking for here. There's nobody else in this country who can tell these respondents that you are conflicted, therefore stop what you are doing, or the proceedings have not started because we have interpreted section 194.3a. That is the exclusive terrain of the court. And I will develop that idea. We'll start there in reply to, depending on whatever my learned friends are going to say. So therefore, in closing, what we're asking for is yes.
Yes.
What we're asking for is Part B, rather Prayer 1 as it is. If we're not successful in Prayer 1 because of some reasons, or what have you, irreparable, then we're asking for the relief in Part in 2. And the issue of the, as Mr. Breitenbach, I think in his notes, points out, the issue of the rescission only features in relation to...
And of course, all the relief you have as an alternative, the 172 point.
Yes, of course. The 172 point, oh yes, the suspension relief. Correct.
That's how
That's the, so, and we ask for purposes which I will develop when in reply, we ask for punitive costs, because in reply I'm going to demonstrate to you that each of these people has dishonestly put propositions here under oath, which they know or ought should have known are false, as the court rules.
Thank you. Mr. Masuku, it's 4:25. I'm going to allow you your full hour, but I'm going to take a 5-minute adjournment.
Thank you very much.
Comfort break for people that want to go to the bathroom.
Thank you,
And then
madam.
I'm going to sit for an hour from 4:30